Yes. Have your lordship kindly give me leave to mention my lord one urgent matter. Determination of the Honorable Justice Shukla Ghosh. My lord,
Appearing in the list.
yes, my lord, before my lord's list. My lord.
Lord,
Please hand over
I'm
this slip
seeking-
mentioning the urgency.
Lord, I am seeking your lordship's leave, my lord, to mention one matter, my lord, from the determination of Justice Lord Shubhra Ghosh. My lord, injunction order passed, police help passed, coordinate bench in the earlier round of
Appearing
litigation.
in the list.
No, my lord, I'm filing, my lord, with the leave so that I can move Wednesday.
Wednesday, for that, why leave is necessary?
My lord, not for that, my lord. Leave your lordship granted so that today I can get the number, serve the, my lord, copy of the writ petition. Otherwise, my lord, I could not able to complete the service. Because one day, my lord, today, the scanning, if your lordship gives leave, that scanning will be made, my lord, on priority basis. That's why.
One day takes a lot of time.
It's a practical difficulty to serve it in
They are also facing difficulty because
unless it
things
is
have to be
endorsed,
done.
they are not.
Scanning also takes time. So that is why usually previously 48 hours, because they are taking time because of this. Because I called them because it's a new practice which is big. For that, they also require time.
Yes.
1 or 2 days more. Yes.
My lord, may I seek my lord's kind leave to mention this matter, my lord, because my lord is very urgent, my lord. Sand excavation from the river bed, my lord. That is, my lord, regulated by the government at that point of time, my lord. They issued a tender.
Group 1.
Group 1.
What
Now,
group
my lord,
1? It's appearing in the list.
No, I'm seeking leave. I move it. I want to move it by on Monday, my lord. The urgency is this, my lord. That is, my lord, that is my prayer. I am before a temple, my lord. I can make any prayer. But otherwise, my lord,
can you not wait for 2 more days?
2 more days means
Wednesday, because if all matters are granted on that, they will be in difficulty. Because
No,
they have to
I am only praying, my lord, if it is a Tuesday, my lord, subject
give,
to, yes.
Wednesday, you can, if you give the date on Wednesday, if it will appear on that date.
No,
why leave is
my lord,
necessary?
my leave is necessary because, my lord, I tell your lordship, because the authority concerned, the newly
It will
constituted,
appear on that date presentation. The date which you are mentioning in the presentation form in this court usually matters appear on that
if
date.
the inquiry is started, my lord, in terms of the MTTCL direction, my lord, which is exactly, my lord, the government says that I should be provided with a challan. The lease deed was executed in 2022. I have deposited.
Wednesday.
No, my lord, I am saying, my lord,
It's taken up
my
on
lord,
Wednesday.
MTCL 29 January 2026 issued an order for inquiry, for further inquiry, my lord, which is beyond jurisdiction. If the inquiry is started, my lord, I can. I am deeply obliged.
But day before yesterday, my lord, I mentioned a matter pertaining to the matter related to the list of Honorable Justice Shubhra Ghosh, my lord. My lord, the matter has not appeared yesterday. My lord, today also it is not appeared.
Urgency.
My lord,
I seen the endorsement in your mentioning slip which you have filed yesterday.
My lord, I have now I have done the I have taken the urgency. I've written it, my lord. May I just hand over?
Maybe that you have not indicated the
Maybe,
urgency.
maybe. My lord, there is urgency. It is now narrated, my lord.
Motion for upgradation.
Upgradation group 1. Mr. Banerjee, please wait because some mentioning slips have accepted, have fixed dates accordingly. After
The only same urgencies, my lord. He is in custody, my lord.
that.
Let it appear on
Same
Monday.
prayer as Mr. Banerjee, but the point is that there is a consent order. My lord, it is item number
So
4.
the upgradation, please wait for some.
My lord, may I be permitted to mention a matter, my lord? Under heading new motions. This is the matter of 2024, my lord. It's pending since a long time.
Motion, new motion.
New motion, my lord.
New motions, please hand over the slip.
For inclusion in the list. Group 1.
Inclusion, motion or hearing?
Motion.
Motions, please hand over the slip for inclusion.
Matter was taken up day before yesterday. The date was fixed on 17th. The parties have a difficulty. Any other date in the next week. So if it can come in to be mentioned on Monday, just for the date change, your lordship. I have informed all the parties.
Date of upgraded matter.
No. It was Mutan matter. It was heard. Mr. Jantokuman Mikuri is appearing for the metro railway. It was mentioned even in the afternoon. Lordship 17, the date is fixed for further hearing. Lordship, I am just praying for a postponement of a date.
Please let it appear on that date, then I will consider. Yes.
Lordship, I am praying to Lordship, I am praying leave to file a matter under urgent circumstances under determination of Honorable Justice Shubhra Ghosh. Lordship, petitioner's showroom has been padlocked by the local political hooligans and more than 3 lakh.
When padlock was put?
Before 2 months.
2 months. What's the urgency? Can you not wait for 1 week? If it was for 2 months, no urgency.
Lordship,
Yes.
police is not
Hello.
taking necessary
Yes.
steps, Lordship.
My lord, praying for a leave of Honorable Justice Subra Ghosh. What
is it?
happened, my lord? Injunction order passed before the trial court. One order of directing the police authorities of this honorable court coordinate bench is there, but police authorities are not taking any steps. In the meantime, in the previous week, my lord, the toilet has been demolished of the property. It's a tenanted property,
Now what do you want?
and my lord, they are trying to forcefully evict us. We are the tenants. We are the tenants. 4%.
Suit is pending.
Suit is pending. Injunction order is there. 151 is pending. One order of coordinate bench of this honorable court is there. My lord, they are also police authorities did not
All
take
right,
any
file it.
leave
Yes.
to file, my lord, on Wednesday, my lord.
Mention the date on Wednesday.
I shall.
Yes.
Your Lordship, may I be permitted to mention a matter under Group 5 for inclusion in the list? Your Lordship,
Motion,
no, for inclusion in the list, Your Lordship.
under what heading?
Under Group 5. Under motion, Your Lordship.
Motions, hand over the slip.
My lord, I'm mentioning from the determination of Justice Subra Ghosh. My lord, the petitioner's son is missing from 24/11/2025. My lord, no adequate step has been taken by the police. My lord, only an FIR has been registered like an unknown miscreant. Still date, no adequate step has been taken for tracing out
File
the
it.
son.
Yes.
May I permit to mention, my lord? It is a group 9 matters, my lord. Inaction of the police. The matter is pending before the Honorable Justice Subra Ghosh, because, my lord, the petitioners has been
Hand over the slip, indicating the urgency. Yes.
yes. The petitioners, my lord.
Please indicate the urgency, hand over the slip. Yes.
It is under group 1, and this application is to be mentioned under motion.
Motion, hand over the slip. Yes.
Lordship, mentioning this matter from the urgent determination of Lordship.
What do you want? Upgradation.
No, Milord, I want inclusion in your Lordship list for urgent hearing, Milord.
Please indicate the urgency, hand over the slip. Yes.
Lordship,
Milord.
yes, Milord.
One matter is they are out of positions.
Please indicate the urgency, hand over the slip.
Out of positions, my lord. They are loitering by hither and
Sir,
thither, my lord.
can you not indicate?
Because, my lord, they are threatening day by day, my lord. That is why this
Can you not
urgency.
indicate that in the?
Yes.
Please indicate
Motion-
matter
motions
is
matter.
considered.
লিখে দিচ্ছি তো। তাড়াতাড়ি।
Please indicate the urgency. I
My-
cannot remember.
My lord.
That is what I am saying. You are not hearing.
My
Yes. Call the list. Yes. This is denotification.
Yes.
Yes.
My
Have
lord,
you
I have
taken
gone-
instruction, Mr. Pan?
I have gone through it.
Yes.
Now, my lord, there is certain problem in this.
Problem.
Yes, may I tell you
You are
the
creating. You are creating.
No, I am not.
You are not creating.
No. I never created any problem. Now, my lord, kindly turn to my lord in my read petition, page 21A. That is a type copy.
21A.
Yes.
Yes.
Total area that has been acquired, it 8,000 square meter. You'll also will find it.
Yes.
Now, that number is, my lord, 61 to 75, 79, 88, 89,
No,
44.
please tell me what happened. What is the dispute?
The dispute is, my lord, now they are
Certain plots have been denotified.
denotified.
Yes.
Now they are acquiring in the order sheet before the competent authority. They acquired plot number 61 to 67 entirely.
Yes.
Now
are
they have
withdrawing
notified
portion.
a portion of the land. So what I am praying as of today, my lord, that let there be a joint determination.
Yes, is it so that initial
Yes.
acquisition was for the entire part, and now you are withdrawing from a portion of that?
No, Lordship, my instructions are that initial acquisition entirety was denotified. That is my instruction.
So entirety is denotified.
Entirety.
So file an affidavit to that extent that entirely you are denotifying.
Yes.
Then there will be no problem, Mr.
No, my lord. Then, my lord, I tell you, lordship.
No, Mr.
because
Pan, if they say
Now, my lord, that denotified itself from it will be evident that if you are kindly take the notification.
yes,
A portion of the land has been acquired, not the entire land. 61 to 67 was entirely acquired. Now they are deacquisitioning the land, a portion of the land. So without the measurement, how I can identify which portion has been acquired and which portion has not been acquired? Why I am telling this, your lordship, my lord? If your lordship kindly turn to page, kindly, my lord, kindly turn to page once.
Page 34.
No, only one thing. Mr.
Page-
Pan, please kindly come to this notification.
Yes,
The which your learned friend has handed up on the last
yes,
occasion.
yes. I have got it.
There, please take up plot number 61.
My lord.
61, the entire area was 4493.64.
My lord. My lord.
So according to you, this 4493 was initially acquired.
Entirely.
4493 was initially acquired. Now please see the next two columns.
Yes.
They are saying area acquired is 1519, denotified is 2974.
But they have to
So
anti-
this makes it the total 4493. So they have indicated here which portion they are acquiring, which portion they are denotifying.
But-
It's evident from the notification.
but the area they have mentioned.
Yes.
The portion that has not been mentioned, whether the right hand side or the middle portion or the left hand side, the portion has not been mentioned over here.
Yes, that you have to do. You have to demarcate that which portion you are denotifying, which portion you are acquiring. Otherwise, there will be difficulty. Maybe initially you acquired the entirety. Now you have chosen to acquire a portion, leaving denotifying a part. Unless you identify that physically, he will be in problem. Then he will be saying encroachment and other things.
Now, my lord, another thing is this. Yes.
What is your instruction on this?
Worship, we can indicate which portion they're saying they have
Because
it
you
on
must
record.
having a plan or a map which will indicate which portion has been acquired, which portion has been denotified. There has to be a plan with regard to this. Or you have to prepare a plan
In my
jointly
pages,
upon them,
jointly.
giving them an
Yes.
inspection. You have to identify the portion you want.
Yes.
Otherwise, he will not be able to utilize the balance portion.
Yes. Now, my lord,
Another aspect, perhaps as an officer of the court, I have to indicate to your lordship very fair submission I'm making. Lordship, the denotification has been done in terms of 93 subsection 1 of the right to fair compensation and transfer. Lordship, what I went through it yesterday, Lordship, perhaps prima facie in my view, Lordship, that does not apply, cannot be
No, but you have taken a decision.
Yes.
There are
Now,
two
my lord,
ways
I'm
that Mr. Please
I have
take
also taken
instructions.
instruction on that, Lordship.
You don't denotify. I think that will be to Mr. Pan's benefit.
I wanted to indicate
He will
from
not be
I
agitated
wanted to
with that.
indicate from my end that this is
No,
what
please, I'm giving you some more time.
I'll
My lord,
come
one more thing. Lordship also kindly indicate them.
Mr. Pan, let
No, my
me
lord, kindly. This is very vital. It just have to indicate to subsection 2. They have to indicate in their report, my lord, this portion also. Subsection 2. They have applied, my lord, in section 93, subsection 1. Subsection 2 is also applicable in my case. Because Metro Railway cannot do this.
This is identical to section 48 of the
My lord,
Act 1.
Act 1. So I have been prevented to use this thing. So I am entitled to have the
So
damage.
this is one of the same points which Mr. Rai argued yesterday.
Not say that.
Yes. Withdrawal is permissible, Mr. Rai,
Yes,
in
yes.
93 also.
Yes, yes.
Withdrawal is permissible,
Yes, yes.
but
No, where possession is
it's
not.
not the stage.
Yes.
It's the compensation,
Yes.
similarly to that of 48. So compensation, Mr. Pan, you will be entitled to.
Yes.
With regard to this, I will allow you, give you leave to apply
the
for
competent authority.
damage.
Yes.
They will decide. That's a different thing altogether.
Yes, yes. But only I want that liberty before your lord.
It is to be ascertained which portion has been acquired,
Yes.
so that
place the plan before lordship by way of an affidavit.
No, there will be joint measurement.
because
There will
which
be
one,
joint measurement.
uh,
This cannot be done unilaterally.
instructions on this. Uh, Mr. Rai is instigating you.
তোর জন্য আমার এটা হলো না তোর জন্যই হয়েছে it is that matter, my lord, wherein, my lord, the stepdaughter-in-law was seeking, my lord, the mutation in respect of the
You have
property.
not taken time on that ground. You told that you want
But this is
you
the
had,
genealogy.
given notice. You did not say that you wanted to engage someone else.
But this is, my lord, the genealogical table, my lord.
Have you given a copy to Mr. Rai?
My lord, here and now, my lord, along with the copy of the previous, my lord, the divorce decree, which I relied on the last occasion.
Yes, Mr. Rai, what do you say?
And এটা দেখে নে আমাদের ওটা হলো তোর ক্লায়েন্ট হলো স্টেপ ডটার ইন ল
The stepdaughter-in-law.
Mr. Rai, if
ও তো তার আগে সিং
Mr.
ইউ আর রাইট
Mukherjee proceeded on the basis, or his submission was proceeded on the basis that the admitted fact is that the property is owned
By Lina
by
Chakraborty.
a female Hindu who died intestate. So if a female Hindu dies intestate, whether you being the stepson of that, or I put it in a different way,
Adopted son.
stepdaughter.
you being the son of the husband of the female heir, female Hindu, can inherit that
Yes.
property.
My lord, kindly consider. I am the adopted son.
There's no, my lord.
Show me that you are the
Yes,
adopted son.
yes.
Yes. Now my
That
lord,
is the adoption. How you have been adopted.
yes. Can you turn to the documents which have been filed?
দেখা হলো
Documents?
পাসপোর্টের নামটা
Filed by
Before,
the mother, the affidavit and others.
mother means Lina Chatterjee,
Yes.
লীনা চক্রবর্তী
Chakraborty.
yes
If your lordship can you turn to page 42.
Yes. 42, yes.
I am the sole lessee of the said plot and I have decided to bequeath my entire 100% share in my property in my son, named Devashish Chakraborty.
adoption no
By way of gift. Show me the gift.
No, that
there's no gift
was not given me at that point.
there's no gift
I am not on that. But
Devashish Chakraborty
query whether I am the, my case is that I am the adopted son.
This is
adoptionটা
Mr.
কোথায় হলো
if you are claiming to be the adopted son, please you have to show that you have the adopted son. This is the document he decided or she decided to bequeath by way of a deed of gift. If you show a deed of gift, well and
No,
fine.
this is
no that is not
page 45.
So that's another thing.
Page
If you
45.
claim to be the adopted son, please show me a document that you are the adopted son.
Page 45.
Yes.
Paragraph 1. Paragraph 4. Now I can turn to
Mr. Rai, what was your age
yes,
at the
page
time of
4.
affirmation of this affidavit?
Which
At the time of affirmation of this affidavit at page 45.
he was born in 1963
51.
Mr. Devashish Chakraborty was born in 1963
What was your age at the time this affidavit was affirmed?
সেটাই কেটে গেছে
Yes, Mr. Mukherjee, can you give me the age of Devashish Chakraborty when this affidavit was affirmed?
Lord, I don't get, Lord, the date of this affidavit.
Approximate age
63.
63.
63
you are
তে
not
জন্মেছিল তার
at the
এভিডেভিট
time of affidavit. This affidavit at
If-
page 45.
there is something August, my lord, I can't read, my lord, that year.
You can take the year, you can take the
No, I
year.
can't read that year.
Where else-
I cannot. It is not very
51 is
little.
48, my lord, will find.
Submitted in 2014.
48.
At the top.
2014 এ কত হবে?
What-
মানে আছে 5 বছর আগে।
Oh, same date.
কোথায়
You have
পেয়েছো?
also-
লেখা আছে 51 ফার্স্ট প্যারাগ্রাফ
ওটা তো
বলছি।
দেবাশিস হ্যাঁ 51 years.
51 years.
পেজ 48 এ ফার্স্ট প্যারাগ্রাফ
Now my lord, page 54.
No, only one thing. How do you explain paragraph 2 of the affidavit at page 45?
I am the mother of Sri Devasishwar Sharamni, Nirmal Kumar Chakraborty.
No, paragraph 2,
Two.
not paragraph
That
1.
neither I nor my husband nor my unmarried minor children, because there is a minor children whom my learned senior friend is representing, or severally hold any immovable property with an urban agglomeration
Yes.
certificate.
So what is the implication of this statement in paragraph 2? There is a restriction that if one member has the property, he cannot get that property. So this declaration is for herself, for her husband and unmarried son.
Neither nor my
Unmarried-
husband nor my unmarried
unmarried
minor
Minor children,
children jointly or
but
severally.
not major married children. What is the implication of this, Mr.? If you say that you are the adopted son, this affidavit cannot help you. Please show me a document that you are the adopted son.
Now my can turn to page
Because you are
58.
relying upon an adoption. Please show me that you are the
No
adopted
adoption
son.
document.
No. Another thing, my lord, page 54, your lordship can turn to page 50.
Even if I accept that you have been brought up, that does not
No,
make you.
foster son is a different thing than adopted
son.
son.
That-
There might be he might be a foster son, but
Page
that
54.
doesn't.
Even if you are brought up,
54.
yes.
Can you
Yes.
turn to next page, page 55.
Yes. It is whose passport?
It's a Lord Devashish Chakraborty's
It is
passport.
whose, at whose declaration, Mr. Rai?
Devashish Chakraborty.
So
So I have
you
to
may
prove.
say, Mr. Rai, you may say someone to be your mother. That person, that lady cannot be, become your mother. It's upon your declaration.
Page 43.
Mr. Rai,
Page 43. Now today my lord is acting to find out.
do you have your birth certificate, Mr. Rai?
No.
Not
Obvious-
your.
Not mine. I'm the wife.
Please
This
show
is
me
to
the birth
certify that.
certificate.
Page 43.
Show me the birth certificate.
I'll come. My lord can turn to page 43.
Yes.
This is to certify that Srimati Leena Chakraborty, wife of Nirmal Chakraborty, aged about 73 years, present residing such and such, is the mother of Devashish Chakraborty, aged 51 years. Such and such, Goriat Road, direct relation, both are very personally known to me. This was given on the basis of the relationship certificate in connection with this document, which is appearing at page 42.
No, what is this relationship certificate is with regard to what?
Regard to my lord for the purpose of permission. Now, my lord can turn to page 42.
Now, what is the challenge in the writ petition?
Yes. Challenge in the writ petition is the mutation made in their
Page
favor of.
58.
Can you turn to now page 58?
All right. So, where is that document?
Yes. Page 58 now, my lord, can you consider?
Yes.
It was executed sometime.
So it was mutated in the name of two persons.
How it? I put this question to myself. If Leena Chakraborty is the sole self, is 100% shareholder, then either it should be recorded.
Please establish your right. Mutation does not confer any title. I will make that clear. If you establish your right,
It's not
title-
created in third party. If the third party interest is created, my lord, then kindly please have to satisfy your lordship.
Mr. Rai, if that is so, you can claim your right in respect of the property in a properly constituted proceeding. I'm
That
not
is why,
using
my lord,
proceeding.
my
In
lord,
a properly constituted proceeding, you can establish your right in this property. I will make it clear that this mutation, this will not create any equity in favor of Mr. Mukherjee's client.
my lord, kindly
All points
Kept open.
will be left open.
My lord, subject to question, my lord, I'm challenging this. Whether this can be done. Can you turn to?
Mr. Rai,
No, I am not on that. My name is not there. Let the civil court meet. Rajashree Chakraborty is the only son, according to them.
yes.
Then how either it should be 100%?
No, but that is because 1/3.
How the Leena Chakraborty
by way of a will. I'm explaining.
This is the Rajashree Chakraborty is 2/3 share.
Yes.
Now he is the only heir of Leena Chakraborty, according to them.
No, Rajosh.
1/3 there is a will.
Rajoshi is my client.
1/3 there is a will in respect of 1 KDA. So 1/3 portion
Yes.
was not milled immutated.
Leena Chakraborty.
2/3 was retained by her. In respect of 1/3, there is a will.
There is a probate
That has-
granted against the will of Leena Chakraborty, where she has bequeathed not 1/3 of her not this particular property to third person. Therefore, the third person not after the probate might have not applied for mutation. So far as it
standing in
stands,
the name of the disease.
yes. And as it stands now, I am the younger son from Leena Chakraborty. I mean, the only son from Leena Chakraborty. My name is recorded.
So, Mr. Rai, with regard to the 1/3, now there is no necessity to take probate. I do not know when the will is.
No, my lord.
It was
So
the before. Nowadays, after the
No, after
amendment. has-
that amendment, my lord, kindly consider 50 square not been touched.
Hmm.
That, Mr. Rai,
That not been touched.
I cannot go into that. I cannot go into that.
But it does
now-
not ipso facto.
No, what is the decision? It will,
Prospective.
in respect of wills or in respect of probate applications.
No,
So if it is in respect of probate
Probate.
applications,
probate.
so when the probate application has been filed, nobody knows whether he will come after that.
So-
If he has not filed, even without the probate, it can
Yes,
be done.
but then
Now
my
the
lord,
question is,
if it is surfaced, then if I raise the objection, then my lord, it is subject matter. Then
or you can, in a challenge to the title of the property, you can very well question that the person who is claiming by virtue of the will may set up his or her title.
that is
That's a
why, my
different-
lord, if your
Mr.
lordship kindly
Rai,
consider.
there is a different thing. One is the deceased executed a will. So with regard to that portion, you cannot, even if you are a son, adopted son of whatever category,
I
you cannot have
No.
1/3 unless that will,
Survives.
if
It's
the will
probated.
survives, you do not have. If the will goes, then
Then my lord.
it's
That
a
is
different thing altogether. Now with regard to 2/3. With regard to 2/3, it has been recorded in the name of such and such, Rajashree Chakraborty, Mr. Mukherjee's client.
client.
So if you establish title, I give you that this mutation will not create any equity in favor of Mr. Mukherjee's. You establish your title to the property.
Only one thing, my lord.
But
leave
as
the
of
third.
today, Lord, if your lordship Lord sees Lord that they are unable to Lord show any iota of title before you, Lord.
Mukherjee, if they can establish their title, these are the facts which has to be established.
But
Whether he's the adopted son,
but
whether
there's
he has title, whether he has some
not
document-
even a case of adoption has been made out Lord with cogent document. With
Yes.
any cogent document.
I appreciate, but I'm not interfering with
My
that.
lord, subject
But
to
if
question,
we-
my lord, this came up for
can prove-
consideration.
Mr. Mukherjee, if you can prove by way of evidence that he is the adopted son and by virtue of that he is entitled to, in a properly constituted proceedings, mutation cannot destroy that right.
No, I never
Today-
say so.
Today some right has accrued in favor
Lord,
of Mr. Rai's client.
That liberty is not required. If they establish their title Lord, on the basis of the declaration, they can always apply for Lord,
I think,
mutation.
if he has not challenged this, then it was fine. Now, once Mr. Rai has challenged this,
Lord, they
if
have
that
not
is-
challenged. Lord, what they have done is that after this was done, they gave a letter saying that reconsider my right to be Lord, mutated.
Now,
That
now-
is a Lord,
now-
afterthought.
Now, Mr. Mukherjee, if I straight away only dismiss that, that will be seen that the High Court has refused to entertain.
Lord, your lordship will
That-
kindly Lord say that unless they Lord establish their title, they don't have any right to apply for mutation. That's
No, so that I will be only observing that this mutation will not give any, will not create any equity in your favor in any proceedings that may be instituted by him. Because merely by saying that it has been mutated, you cannot say, no, I am the owner.
Lord, mutation even doesn't Lord confer ownership.
That is why, Mr. Rai,
My
I
lord, can you
think-
consider the Uttam Kumar's judgment board vicious, paragraph 19. What constitutes for the purpose of adoption?
no, Mr. Rai, I cannot
So
decide
privacy,
that
I have to
will
satisfy.
Mr. Rai, I cannot decide the issue of
That is my
adoption here.
precisely.
I cannot also decide the question of title here. Prima facie, what Mr. Mukherjee was saying, till now, prima facie, you could not establish. You could not
So
produce any
prima facie, my lord, can you consider what?
was the only basis of your right was a deed of gift.
No, it is
Proposed to be
proposed to
given
be.
by, yes,
My lord, can you?
proposed to be given by Veena Chakraborty in your favor. That did not happen. Now you are trying to make out a case of adoption,
No.
son, because that Veena
It was
Chakraborty
my
accepted
pleadings,
you
my
as a
lord,
son.
your lordship, can you consider my pleadings is that my husband was the son of Leena Chakraborty. This was the specific pleadings made in the writ application.
Mr.
Now they dispute.
That doesn't make, Lord, that he being the son. Inheritance.
Mr. Rai,
Inheritance
there is
doesn't,
a
Lord.
dispute with regard to that.
That is why.
So you have made out a case that you are the son.
And
Mr.
I say no.
Mukherjee says
I'm not the son.
denies that. That issue with regard to the status of a person
Yeah.
that cannot be declared in a writ court.
Precisely, my
As
lord.
to your status that cannot be declared. So now with taking aid of that status which you are claiming, you want a title in respect of a property. Agitate that in a properly constituted
And my lord, what
proceeding.
the deed and other things, my lord, that was subject to question, my lord, that was considered by 1992 DMC, page 312, paragraph 19. The Uttam Kumar's Gaur Vishwas judgment.
What deed? Adoption.
Adoption deed does.
Mr. Rai, I am not
9, 10,
entering
and
into
11
that.
section does not prosperate.
No, I'm not saying with regard to the adoption deed, but you have to prove the adoption.
Yes.
On the lordship will see whether the
Giving and
case of
taking.
adoption is made out in the
Mr. Rai,
petition.
I am saying son.
Mr. Rai, the
not
giving and
adopted.
taking, the
Yes.
giving and taking
And I'm
aspect of,
renouncing from that family.
Dattak home and, Lord, the deed.
Not only that.
so giving and taking
Taking.
is to be proved. That cannot
That-
be done here.
Yes.
But the case of adoption has not been spelled.
I
out
say
in
I'm the son.
the writ
What
petition.
do I
He's
say?
arguing something, but that is not in the writ.
I say I am the son.
Now
And
he's
I have
saying
shown,
adopted.
Lord, before your
Where
lordship
is
that
the
he is
pleading?
not the son of Leena Chakraborty at least. And there's a divorce decree containing his,
Where is your birth certificate, Mr. Mr.
her husband's name is contained in the divorce decree.
63. And I am the wife of the deceased.
SIR?
কে কে নাম ডাক পাচ্ছে কে জানে না?
Your client's name has been
No, he is
in the electoral rolls.
he was staying at Delhi.
Any objection, Mr. Rai, your client received?
Her husband died in, Lord, 2000. And thereafter, Lord,
Subject to question, my lord.
the mother, the Leena
2020,
Chakraborty, 2020. And mother died in 2023. Leena Chakraborty. So Devashish Chakraborty, her husband, he died, Lord, prior to, Lord, the death of Leena Chakraborty.
But Mr. Mukherjee, if he is the son, he has any right to inherit,
Lord, only
then
thing,
the wife will inherit.
Lord, there is a decree which names, Lord, Devashish Chakraborty is son of Pratima Chakraborty. The decree I have, Lord, relied upon your lordship. And I have handed over a copy to my learned friend.
I'm saying
And
that
he
I'm
was,
the
Lord,
son.
7.5 years at that point of time.
Now, Mr. Rai,
And it was in 1990, if I'm not wrong.
Mr. Mukherjee has placed them on the other day. So that shows that your mother was Pratima.
Pratima
His
Chakraborty.
natural mother was
Pratima.
now Leena was not your natural mother.
That is why, my lord,
So
adopted.
if, yes. Now
Now adopted. I am not saying that I am Leena Chakraborty. I'm
you have
saying
not disclosed that in the
I'm the
writ
son.
petition, you have said only son.
Son.
Only son.
Not only son, my lord, I'm the son.
How?
Yes,
Not
but
the natural son.
that-
Mr. Rai, if you take that plea, in view of that, you cannot be said to be the son.
my lord, can you
In view
consider?
of that decree,
That is why adopted.
when-
Now, my lord, when my status has been challenged, my son, no, you are not, you are the stepson, you cannot be the adopted son or son. Then, my lord, I have to prove that yes, I am the adopted son. Once I prove the adopted son, my lord, then, my lord, I am entitled to 15(1) will come into my head, the Hindu Succession Act. The son includes adopted sons.
No, never.
Yes, subject to question, my lord.
Kindly.
you have the mullahs
Oh,
Hindu.
Lord, that is, Lord, the Supreme Court judgment is there. Lord, I can produce that.
Yes. Stepsons,
It
that
is-
relates to stepsons.
Of course, Devashish is stepson.
Adoption
No,
case has not
that
been
is-
made out in the writ petition. How can he argue on that, Miller? There's no
How
case
can
made
you
out.
anticipate what will be the objection?
No,
I
No, no, you have
Make
to
out
take
the
out your
case. What
case
is
in your
this?
writ petition.
Yeah,
That doesn't
claiming to be the
It
son.
is not within the four corners of the writ petition.
can't keep something in your sleeve.
There has to be averment first to take that point.
এটা হচ্ছে
These are not question of fact he is raising. এটা কিন্তু নিতে পারেন, he cannot take without averment.
সান বলেছে
Son,
অ্যাডপশনটা কোথায় বলেছে
where is the challenge regarding my status? As of this day, this challenge come.
Stepson.
No,
Which
adapted,
article you
sir.
are referring
Yes.
to?
That is 1994, volume 1, CLT, page 395,
Please give it.
paragraph 14 and 15.
94 ভলিউম কত
For the purpose of inheritance.
Yes. 94, volume 1, CLT, page 395.
Does it contain Adoption and Maintenance Act? This,
Yes, my lord, kindly turn to paragraph 11. Paragraph 11.
this book contains the Adoption and
No,
Maintenance.
it doesn't. That one only the Hindu Marriage Act and the succession.
Do you have the copy of the Hindu Adoption and Maintenance
Yes, my
Act?
lord.
ওটা- ওটা-
9, 10, and 11.
জাজমেন্টটা নাও না তোকে নিয়ে নাও
হ্যাঁ, ও পড়ুক।
And my lord, kindly consider paragraph 11 of that.
Please give me a minute. I'm searching something.
Yes, বলে কি বলছে সেটা বুঝতে পারছি না। After saying yes, this is very much troubling word for us.
To whom it is yes.
Yeah, that is. My lord, kindly consider paragraph 11 of Justice Chatterjee's judgment.
এটা কিন্তু ডিসমিস হওয়া উচিত সাপ্রেস করেছে
হুম?
সাপ্রেস করেছে তুমি সান মিন্স ন্যাচারাল সান আফটার সান ইউ হ্যাভ টু মেনশন this is dealing with the effect of adoption.
Yes, this judgment.
This will take into effect once adoption is proved.
Yes, that is why.
So please establish your adoption in a properly
Yes,
constituted.
that precisely what my learned senior friend is submitting today. I have to show prima facie document is where my
There's
mother
no prima
said-
facie document
Yes.
at all.
There is no
Merely your
A declaration of
I am a
part
son
of the- my
somebody,
mother.
that's your son.
Malad Kari consider.
mother do not declare you as a
Yes, Malad Kari is subject
Mr.
to
Mr. Rai, mother do not declare you
as a son.
that declaration has to be considered as a whole.
Yes, that is why Malad Kari consider.
Mr. Rai, there are two things. Son is not prefixed by the expression either adopted or
Or
step.
stepson.
So you can be either adopted or step. You are a son, no doubt. But whether you are an adopted son
Precisely.
or a stepson, that has not been stated. And paragraph 2 is very relevant because declaration, the effective declaration for the purpose of which that was done was only to say neither she nor her husband nor her children. So there you have been left out. So though she recognizes you, maybe even a foster son,
That if that be so, Malad Kari
may
turn
even
to
be a foster son.
page
But
42.
foster son doesn't have any right. Only the adopted son might have a right.
Page 42.
So adopted stepson might be a foster son either.
No, Lord, not necessarily. Why I say this,
If-
Lord, I can also consider somebody who is not even a stepson to be my foster son.
Yes. Yes, yes.
কি বলে পাতানো না
পাতানো,
That may be.
Yes.
So
If that be so, my lord, I am the sole lessee of the said plot. I have decided to bequeath my entire 140 in my favor of my son, named Devashish Chakraborty, resident of such and such, by way of gift, enclosing with the requisite documents. Where you have said,
already you establish your
Yes.
adoption.
Lord, will kindly not, Lord, say that the mutation will abide by, Lord,
Yes.
the result of
No, no,
this,
no.
Lord. Otherwise, Lord, that will create a clog on my, Lord, the mutation.
You
But the
will not
difficulty
take-
is let them, Lord, establish. If they establish,
considered.
Judge of Justice Bhaskar Bhattacharjee, sitting in WPLT, same things happen. His lordship of the opinion that private dispute cannot be without
Whether Bengal Survey Act was considered there.
any
The division bench judgment.
division makes sense.
Can you give me that copy because only single bench decisions were
I will supply to you.
because I have the decision of 1881.
There
That's
is an
the parent
application for
decision.
demarcation.
That was the parent decision on Bengal Survey Act.
No, here, my lord, what happened? An application was filed for demarcation. The procedure
This is
was
might be under the Land Reforms Act.
no, it was said by Justice Bhattacharjee, sitting in division bench. So the private party is concerned. there is no authority or the authorities can be involved for the purpose of
No, that
demarcation.
is considering, I think, Land Reforms Act. But I do not.
That
Bengal Survey Act, I do not know. Some decisions of the coordinate bench was produced, but no division bench judgment. But I got hold of a division bench judgment of 1881.
যাওয়ার কি দরকার আছে অত পিছনে
No, that considered, Mr. Rai, that considered the effect of the Bengal Survey Act, how it proceeds. I think Mr.
81.
Banerjee also appeared in that
I did
matter.
not appear.
You did
I'm
not
asking for
appear.
the judgment from Mr. Rai.
Aniruddha Chatterjee appeared. Mr. Surajit Nath Mitra appeared for the both sides. Mr. Thakkar
Mr.
also-
Court there, Mr. Mitro.
Mr. Surajit Nath Mitra on one side, Mr. Aniruddha Chatterjee, Mr. Thakkar, I think Supratim Dor or
It was
someone was
withdrawn,
also.
our judgment has been delivered by your lordship.
No, they have withdrawn. After I
Shall not get the benefit of all
after
the.
I gave them the judgment, Mr. Mitra withdrew that. The writ petition.
I had a talk
In
with
that demarcation.
Mr. Mitro regarding this. I said that it is not subject to question, it is not because there's certain judgment which cannot, private property cannot be demarcated in a fashion.
Because I told him that you argued in one matter, you produced a judgment, then you took it back. He took it back. He said, "No, I'm not relying upon that."
That is why I've said that.
That is why I told that he is having one decision, because I've seen a decision which says demarcation is permissible under the Bengal Survey Act. That is why.
Banerjee, as is lordship.
That is the
ওইটা
That also cannot be decided here, Mr. Mukherjee.
No, I know that I was very reluctant unless I was prodded for the fourth time to not
Yes.
না দুটো বই না একটা বই
One is, I think, of Mr. Mukherjee.
এইটা তোমার দেখছো
My lord, item number 3 on behalf of the petitioner, my lord. The petitioner made an application under section 10
But I'm for the respondent number 12, 19 and 25.
for the demolition of illegal
13, 14,
construction.
15, 16 and 21
Collusion between these two sets of
Yes.
private respondents.
Collusion বলছি তুমি হ্যাঁ বলছো
দশে
আমার এটা
কই কই
এখানে disposed of. It's a
Paragraph number 4, my lord. My cause of action. Paragraph number 2 is the details of the Rayati plot, that is 89. Very clear in paragraph number 4, my lord.
Why you file the civil suit?
I'll suit for partition.
declaration
Declaration of title and permanent injunction.
Actually,
Not a suit for partition, sir.
Declare and not to disturb the encroachment. Last prayer, my lord, if your lordship kindly consider the prayer made therein. No, his cause of action for filing of the suit that he is the owner of 89 and there is obstruction. He failed to prove that he is the owner of the 89. Then how this writ petition be filed on the basis of the abandonment that he is the owner of the
Kindly
89?
see the paragraph number 4, my lord, once.
Of the writ petition.
Yes, my lord. The private respondent, without taking any permission from the concerned authority, have erected several unauthorized and illegal pakka construction over the government property that is on the abandoned portion of the land of PWD.
How he
Anything-
Wait.
Yes.
By covering and blocking the front portion of the above stated petitioner's Rayati land.
yes 89.
Front portion, my lord.
Private respondents are the defendants in the suit. These private
Yes, my lord.
respondents are the
Yes, my lord.
defendants in the suit. Have you challenged this decree?
Yes.
Yes, my lord.
When have you preferred the appeal? When have you preferred the appeal?
My lord, I have to take instruction, my lord.
Appeal is pending.
2023.
I am here, my lord, to removal from the public property.
The petition Maybe, but your title has been, you could not establish your title.
My lord,
Yes.
affidavit of service.
Taken on record. Yes, next. Yes.
I am appearing on behalf of the petitioner. My lordship, the affidavit of service.
Private respondent served.
Yes, my lordship, has been served and delivered, my lordship. Has been served and delivered, my lordship.
Delivered. All right. Yes, what is this matter?
My lordship, the matter is a very short one. In the year of 2022, I am the owner of one vehicle, and I have given the said vehicle for driving purposes to the private respondents. And then thereafter, in the 2024, I have seek the vehicle back to myself, but the private respondent has denied to do so, and subsequently I have preferred an application under section 97 of the BNSS before the learned court below, where by the order dated 19th December 2024, the learned court below directed the respondent number 4, the officer in charge, to search the vehicle with the help of the petitioner, my lordship, which is reflected in page number 16.
Yes.
Well, this is police report, my lord.
And subsequently, as no action has been taken by the respondent authorities, on 9th December 2025, I have made one written representation before the respondent number 3 and 4, my lordship. But still no action has been taken till date.
Well, after investigation, my lord, petitioner made out, my lord, one agreement done, private respondent and petitioner, lordship.
Agreement for sale.
Agreement for agreement for sale, my lord. My lord, kindly see report, my lord, page 58. 58. One notary
How can a
public.
dispute can be decided?
My lordship, I have
Civil
taken
in nature,
instruction for
lordship.
that, my lordship.
Please file a civil proceedings.
Take one copy of the report, my lordship.
Please give a copy. I'm coming after 5 minutes.
Now,
Five, my lord, I'm for the petition.
Yes.
The service, my lord. And yesterday I mentioned the matter before lordship intimation.
Yes, any private party?
No, my lord.
Yes.
The issue is the petitioner is a trust. Joyma Om Shamsundari Dharmakrishna Devotta Trust. They have previously they had a temple in Amar Street area. Some problem arose due to intervention of local political leaders. The political leaders wanted to be the president of the trust. Subsequently, they had to left the place with the idols. With the idol of Ma Shamsundari. They went to Odisha. Subsequently, they established a temple in Mukundapur. And after purchase, earlier accommodation was a rented one. Subsequently, they have purchased a property in that particular area. They have started a temple over there. Regularly, visitors visit the particular temple. Since 2024, again problem arose, my lord. Again, some political leaders, they created some pressure upon the petitioner, stating that yes, you are running a temple, visitors are coming, devotees are coming, so you have to do something for us. By creating pressure, something was taken. Subsequently, they again created pressure, stating that you have to sell prasad, and we will take care of that. But they didn't pay any heed to it. On 18th January 2026, my lord, Moni Amavasya was there. During Moni Amavasya, certainly different visitors visited the particular place, and after seeing the gathering, police ordered the petitioner to close down the temple. Everything was done after intimation. On every occasion before Amavasya, intimation was given. Earlier, they used to receive the intimation. Now they said, okay, just inform us over phone. On 18 January, after closing the temple, the devotee who came from different parts of West Bengal across and also India, they created some chaos because they couldn't enter into the temple. And that created a chaos in that area that put police lathi charge, and there was a scuffle between the devotees and the police. A case was registered. A case was registered against the trust, against the trustees, and police is directing them to control devotees, not to allow devotees to enter into the temple, not to do any live telecast of the puja and other things. Police is interfering in daily affairs of the trust. But the trust is registered one. I am paying income taxes. On every occasion, I have intimated the police. My lord, kindly comes to the complaint once, my lord.
Complaint made by you?
No, my lord. Complaint against me, my lord.
Against you?
Against me. Page number 40.
Want now?
But I want protection. Let the police not interfere in my daily affairs of the trust. First prayer, my second prayer.
Have you complied with this notice at
Yes,
page 43?
Yes, my lord. Yes.
You have complied?
Yes, my lord.
You have submitted those documents?
First call, I went there, my lord. Second call, I have asked for certain times. I am ready to supply all the documents. Ready to supply.
So when can you supply those documents?
But tomorrow I can supply.
Yes.
But let 2-3 things, my lord. But the puja is we have devotees across the world, my lord.
Yes.
They want to see the temple during the puja. Police cannot direct me to stop live telecast, so not to publish any video, not to do anything, not to allow devotees. But this is direct interference of a mandir. A devotee, I'm asking the question.
Lordship, my senior Mr. Vimal Kumar Shahi is for the state. I'm led by Mr. Vimal Kumar Shahi. I have the report of officer in charge.
For more than 3 hours, I was grilled, my lord.
How many devotees regularly visit your temple?
On regular days, more than 400, my lord. On special days like Moni Amavasya and Amavasya, normal Amavasyas, more than 1,000. And on special days of like Kali Puja or special occasion, the number is not limited, my lord. On last occasion, it was more than 3,000, my lord.
So did you intimate the police
Yes, my
of
lord.
this?
On every
Show
occasion.
me you intimated
My lord,
the
my lord.
police. When did you intimate the
My
police?
lord.
Because
Pe-
some sort of arrangement is to be
Yes,
made.
my lord. Kindly comes
Because,
to
your temple do not is not that big, so that it can all the devotees.
my lord, kindly comes to page number 41.
So it should not also create disturbance.
No, certainly, my lord.
So you also require
But-
the assistance of the
Exactly,
police
my lord. I am not
for the
in.
purpose of controlling.
But I am not.
So you have to make them known about this in advance.
Page 40, my lord.
40.
40.
Yes.
It's 18 November 2025. Before every occasion, my lord, I used to submit this kind of representation. Certainly, they stopped taking any, just inform me, just inform us over the phone. And after that, we are doing that, my lord. Even on
Who inform you over the phone?
the particular Amar Street police station, my lord, from earlier, we used to submit a written representation. Subsequently, the police station said, okay, Maharaj, just do.
You can control the devotees. You can maintain that there will be no traffic control. There will be
Madam,
no
I even personally, we personally
if you cannot control, there has to be someone
yes, my
to
lord.
control. So suggest the means how it can be
Madam,
controlled.
every time on every occasion, we hire security officials. Madam, kindly come to page 42 once.
So give a definite proposal to the police
Madam,
authorities stating what steps you are
Madam,
taking.
I will.
How many persons, according to you?
Man,
will
I will give my volunteers on every occasion. I am.
How many persons? Where
I will give detail, my lord.
Where they will stand.
I will give detail. Everything I will give detail. But let.
But you have not given in those lines any of the.
My police never asked me, man. Kindly come to 42 once.
Sir, it's not the police who will ask. Police do not know how many devotees will come.
Kindly.
It's after because you know how many devotees will visit your office.
My lord, kindly.
Your temple. So you must make them known that so much of devotees will
yes,
come.
my lord, 42.
So this arrangement I am making in this way. This is to be done. So you have to make known to the.
My lord, kindly see page 40 once.
Because after all, you want the devotees also to visit.
But I don't want any devotee should not get hurt, my lord.
Yes.
That's primary concern.
That's one thing. You also do not want, you also have to
Cause disturbance to others.
Yes, that it should not cause
Yes,
disturbance to the others. So for that you have to do something.
Man, kindly, I'm saying, man, kindly come to page 40 once.
40?
40.
40, yes.
Dated 18 November.
Yes.
On behalf of Joyma Om Shamsundari Dharmashetra Devotta Trust, Indrashan Bhattacharya, head priest of the temple, humbly requesting the concerned authority intimation on upcoming Saturday, that is this month, and Amavasya, that is on 19 November 25, at Joyma Shamsundari Temple, located in Sunset, Kolkata, 1,000 devotees.
It happened on November. So
every
now,
time.
what is the special occasion which is forthcoming now?
16th of this month.
16th of this month. So you give a letter indicating how many devotees are likely to visit
and my arrangement.
Temple, what arrangements from your end you are making, and what assistance from the police authority you are seeking.
I will.
And please.
And one more thing, my lord, I'm just asking the question to myself, my lord. Kindly seize the complaint once, FIR, page 45. 45, the formal part, my lord. 49 is the actual part.
Yes. What do you want?
But I want stay of this proceeding. I am not involved, my lord.
Let it be investigated, not stay.
But
if you are not involved, that will be
let not coercive steps be taken, my lord.
Let the proceedings continue.
But I am. I shall
not in any way involved. The proceedings will be ultimately. It's only an investigation done.
Let no coercive step be taken up.
Please comply with this because you have sought for time, 31st of January. So you are ready to produce all materials before the police authorities.
The documents which I have, I am ready to produce.
I am giving you leave to produce the materials and also to state in particulars, make a detailed representations stating what arrangements, how many devotees you are expecting, what arrangements from your
and timing.
and the timing, what arrangements from your end you will be making, and what type of assistance
I
you
want
need
from
from the police.
I shall, my lord, I shall. But let the police not to interfere into my daily affairs of the temple, not to photograph, not to videograph.
You please, yes, are you prohibiting them from publishing these video images and to live telecast this puja?
No, no, Lordship.
And that is complaint.
What?
That is a complaint. It's line of a complaint that I publish photographs to attract devotees. That is the complaint.
You are denying
My
that?
devotees want who are outside.
Know how it is done.
My
Know
lord,
how
if
it is done, how these social media platforms are being
my
used
lord,
for this. I'm not saying anything with regard to that.
all temple across India, all religious places across India does so.
Deny that I'm not doing this type of to attract.
I'm not doing this to attract, my lord.
So that you are not doing that to attract.
But
You are only live
in
telecasting.
official page that is uploaded. I'm not asking anyone to do that. The official page of the mandir, it is uploaded.
So during investigations, you will satisfy them that I am doing this. This does not amount to attracting. I'm only live telecasting. Live telecasting is one thing, and doing something in addition to attract extra devotees.
My lord, I'm just asking question to myself.
Know the social media
My lord,
platforms.
I am asking the question to myself.
Going to that, Ashun, the learned advocate appearing for the petition.
copy of the report, my lord.
Yes, please give a copy of the report. Yes, call the next matter. Yes.
Ma'am, for the petitioner, I'm led by Advocate Shapushai Chatterjee. The leading counsel is engaged in court number 14. I will assist your
Yes.
Mr. Lordship. Lordship, in a nutshell, the petition is aggrieved with the act of the respondent police authorities for arbitrarily denying them the permission to organize a peaceful protest rally on the 16th, in spite of the fact that the petitioners have made.
Where?
Your Lordship, that is annexed in page number 23.
Which area?
Your Lordship, APC Bhavan, Bikash Bhavan.
Bikash Bhavan.
Yes, Your Lordship.
Yes, you have applied for that.
Yes, Your Lordship.
They have rejected.
Yeah, they have orally rejected, Your Lordship. They have not given any documentary. Yes, Your Lordship.
Yes, Mr. Additional Advocate General.
I am told that it was communicated to them, but my lord,
You have rejected.
I have rejected.
Why?
Logically, go.
Are they not entitled to hold any protest rally?
Well, everybody is entitled. They
So-
are also entitled, but subject to my lord, so that there would not be any inconvenience because of time. Everything is necessary. My lord, they want to.
Mr. Shane, you have to. You are not. You are not opposing
regarding rally, but I may oppose with regarding to the day, timing. These are all these things and the place.
What is your objection first with regard to the date? Let us come stage by stage.
My lord,
What is your objection with regard to the date?
16th, according to them, they want to, my lord, a rally to cover 1.5 to 2 kilometer road, public path, and they would take, according to them, from 11:30 a.m. to approximately, my lord, to 4 p.m.
4 p.m.
And their
2
application is rally for 2 kilometers.
2 kilometers you will take from
Yes,
11 to
according
4.
to them, Monday.
can-
I'm coming one after another.
How much time it takes? Do you have an idea?
Your Lordship, we can reduce the time.
2 kilometers, how much time it takes?
We can reduce the time, Your Lordship, subject to my
But
land.
when you file an application, your intention is that you will
Yes, Your
do
Lordship.
that. So you have to be reasonable also.
Yes, Your Lordship.
So do you have an idea how much time it takes walking for 2 kilometers?
And according to them,
I'm asking you,
1,500.
I'm not asking your client, I'm asking you personally. Do you have any knowledge how much time it takes to walk 2 kilometers? Do you walk or you do not walk? You
Yes.
always ride by
No, Your
four-wheelers?
Lordship. Your Lordship,
Walk.
yes, Your
How much
Lordship.
time it takes to walk?
Lordship,
to-
1 hour to
2 kilometers, 1 hour.
This shows that you do not walk, you ride through. All right, let us not go into that. Yes, so first is Mr. Shane is the
Yes.
timing.
Timing. Then, my lord, kindly come to my lord, there, my lord, the application at page 24. At
Yes.
page 24.
Yes.
This is a follow-up representation, Your Lordship.
একটু আমি জটকে
Yes,
বুঝিয়ে দিই তারপর
Yes, 24, yes.
বলবে we propose to organize, have you lordship got it, my lord?
Yes, yes.
Page 24 at the middle portion. We propose to organize the said rally on 16 February 2026 from 11 a.m. to 4 p.m. Now, let us, my lord, fix the time. Otherwise, now, my lord, kindly come.
What according to you would be the suitable time?
Now, I'm coming to on that day, my lord. It's a schedule of the ISC examination 16, and my lord, just where from they wants to, my lord, start the rally, my lord, just within, my lord, 200 meters, my lord,
All right.
one of
So-
the, my lord, the examination.
So the
center.
examination will be from which time to which
Yes,
time?
I'm coming. That is why I'm timing. That is why. Because they totally rejected, then I, my lord, also proposed them that the timing and
That
the,
is why, Mr.
Yes,
Sen, I'm asking you,
my lord.
what should be the
This is
reasonable time according
my
to you?
proposal, my lord, the exam will start from 2 p.m. on 16th. I see. Now, my lord, the proposal is, my lord, the timing. Of course, my lord, after consultation with them, now the timing is from 11:30 to 12:30.
That can be done.
That can be done. 11:30 to 12:30.
But if from 2
Because
PM
by
the
that
exam,
time, there are so many offices. By that time, my lord, so far the, my lord,
Alright,
the office.
11:30 to 12:30.
Yes. First of all, 11:30, 12:30.
Yes.
Now, my lord, kindly come to this, my lord. Their starting point from DL 100, DL Park. Rally will start from. Have you also got
Yes,
it, my
yes,
lord?
yes.
The second sentence. The rally will start from DL 100, DL Park, DL Block, Sector 2, Bidhannagar, Kolkata. Then culminated Vikas Bhavan, 3rd Avenue, DF Block, Sector Bidhannagar. This 1.5.
So culminate point we cannot change.
No, I'm not on that.
Yes.
I'm not.
Because
But
They
But
have to
the-
visit that office. So,
Yes, but the starting point, Lordship,
yes,
kindly come
what
to,
modification you want?
my lord, Lordship, kindly come to second page of my instruction.
Second page of your instruction.
Yes, I one after another.
Yes.
Second page of my instruction.
Yes.
At the top. It is pertinent to mention rally is proposed to start from DL 100, which is a residential place with narrow block lane. If such large number, according to the 1,500, if such large number of people is permitted to gather there, it will create panic and fear among
The
Islamic
nearby any adjacent place.
adjacent place. I am coming now, my lord. My proposal is, Lordship, that my lord, they can start many, my lord, the rally they start from this, my lord, but that's my lord, 500 meter, my lord, ahead, my lord. That is, my lord, Saurabh Ganguly Cricket Academy. Saurabh Ganguly Cricket Academy, there, my lord,
It's
there
near
is a,
this location.
yes, location.
DL 100.
Yes. So from there, from this Saurabh Ganguly Cricket Academy, there's service road. They can avail it. They can avail it,
Yes.
and they can also, my lord, culminating or end it to their, my lord.
Because Bhavan, that has to culminate there.
Yes. So this is our proposal.
So what will be the route from Saurabh Ganguly Cricket Academy to Vikas Bhavan via?
Well, via road to then to Karunamoi, then Karunamoi crossing straight away.
No. The starting
and
point.
then to Vikas Bhavan.
No, the starting point you want shifting, but
Yes.
the other points via route will also change. Or
no.
No. Can you not arrange some portion of that route? Starting point I appreciate, but
Yes.
some portion of that route, if can you not agree to that?
Well, these smaller straightway they can reach to the Karunamoi crossing, I'm told, and I have very little idea about Salt Lake.
I also do not have that
Yes.
much of idea. Your authorities. No, Mr. Sen, is
Yes.
only one thing you can take instructions that if any this via. Mr. Sen,
Karunamoi crossing via
Mr.
ঠিক
Sen,
আছে।
only one thing. Please ask your officers
Yes.
whether starting point I appreciate.
Timing also.
Culminating point cannot be changed. But the
yes.
route which they have proposed,
My lord.
if we shift the starting point to somewhere else,
Yes.
and some portion of that route can
All
be
right.
maintained.
Follow.
So please ask your officers
Follow,
with regard to that.
Follow.
Please ask your officers with regard to that.
এখানে আপনি তো ওই থানাতেই আছেন, আমাকে একটু মানে
এরিয়া টোটালটা রেসিডেন্স এরিয়া কোনো অফিস টফিস কিছু নাই এখান থেকে স্যার
ডিএ ব্লক সেক্টর 1 বিধাননগর এখানে
সব রেসিডেন্স এরিয়া ডিএল পার্ক সব পুরো উপরটা স্যার রেসিডেন্স এরিয়া
আপনি কি বলছেন এই
আমরা বলছিলাম স্যার সৌরভ
টিকেটে হয়ে গেছে
ওখান থেকে করুণামী ক্রসিং থেকে বিকাশ
ওখান
ভবন
থেকে যে করুণাময়ী ক্রসিং গেলে এখানকার কোনো রাস্তা কি ওরা পাচ্ছে না
হ্যাঁ ওটা এপিসি ভবন যদি যায় তাহলে এপিসি ভবন ঘুরে ইউটার্ন করে আসতে হবে
থার্ড এভিনিউ হয়ে এপিসি ভবন হয়ে আসবে করুণাময়ী হয়ে যাবে
করুণাময়ী হয়ে আবার
করুণাময়ী হয়ে থার্ড এভিনিউ যাবে হয়ে তারপরে এপিসি ভবন হয়ে
বিকাশ ভবন
What will be the entire stretch? What will be the length of the entire stretch? How many kilometers?
My lord, if it is, my lord, as per
Sir, Sen,
the
please
suggestion
suggest it
made.
to them. Please suggest. Yes, sir. Please consider this suggestion. Please tell it to him.
শোনো এই সৌরভ গাঙ্গুলি ক্রিকেট একাডেমি সার্ভিস রোড থেকে ওরা করুণাময়ী গিয়ে করুণাময়ী যাওয়ার পরে এইখান থেকে থার্ড এভিনিউ ধরে নেবে। থার্ড এভিনিউ ধরে তারপরে এই যে তোমাদের যে রুটটা দিয়েছো সাজেশনটা, থার্ড এভিনিউ এপিসি ভবন দেন বিকাশ ভবন, এটা
So the starting point will change, but from third avenue
start. Yes, third avenue to APC Bhavan and APC Bhavan to Vikas Bhavan.
And what will be the entire stretch length of
এটা কতটা? I have to bar logo.
1.5 is something.
এটা I think I'm told 2 kilometers.
They are saying 2 kilometers.
2 kilometers.
They are also saying 2 kilometers.
Yes.
And all right, from 11:30 to 12:30 you are saying. So that will not hamper the
That will not
exam,
hamper, yes.
exam also.
Yes, exam,
And,
because exam will start from 2 p.m.
And any,
Matlab the
no other
institute-
objection you have? You don't have any other objection?
Any other objection?
Because
means-
participants, they said 1500 to 2000. That and sufficient number
But,
of
but I am told that on earlier occasion, after obtaining permission from the court, my lord, their permission was for 1,000, and my lord, actually participants were more than 2,000. So that should not be, I think.
that I think when Mr. Chatterjee is there, he will restrict
My
it.
lord, these are these candidates. These are not the political parties rally, so candidates' number will be
Mr.
restricted.
Chatterjee, I'm not with political parties or what. Two things. One is you are not there. One thing is timing.
Yes.
So according to you, 2 kilometers cannot take 5 hours.
No.
Because your junior do not have any idea about walking because he travels by 4-wheelers. I think also you do that. But
We
you
have
may not
some-
also have any idea.
No,
how
but
much time it
idea,
takes.
because he
Yes.
he has to compulsory on walk.
Yes.
My
So,
lord,
all right.
no, one thing, on that date, there's an ICSE exam. So you also, being part of the education, you also do not want disruption of any examination. So Mr. Sen says from 2 p.m. the examination will start. 2 kilometers will not take more than 1 hour. So he suggests from 11:30 because office goers will be there, 11:30 to 12:30. So I can make it, Mr. Sen, can it not be from 11 to 12:30? So from 11 to 12:30.
I leave it to
because
সবকিছু
from 11 to 12:30.
Yes.
And the culmination point has to be there because cannot be changed.
Yes.
Only the starting point, what you have said from DL 100, Mr. Shen's instruction is that that's a residential area with a very narrow lane.
Narrow.
Now, he has suggested a starting point from Saurabh Ganguly Cricket Academy
It just passing.
through
200
Corunamai,
meter.
then from this 3rd Avenue, that stretch will
এখান থেকে।
continue.
ঠিক আছে?
Agreed, my lord.
My
The by calling them.
My lord,
Necessarily, you are troubled. Mr.
practically,
Chatterjee is also troubled.
practically within
Our duty is to
practically-
consider the matters and to deliver.
practically-
But both of you are troubled. by
practically right now here within 15 minutes, my lord, I
that
have
could not have been done earlier.
yes. Now I received the brief only today
I'm
morning.
not asked.
Oh, I see. Yes, yes.
I'm not.
I have
taking
followed, my I have followed. Yes.
Why this type of matters unnecessarily? This is being. They are also agreeing. You could have given them this suggestion. It's not that they are not agreeing. Some these things,
Yes.
that things will be there. They have
But I am not
used-
sure that they would have
And
agreed
Mr. Chatterjee, only you have to restrict
outside court. they
because
have
your
agreed.
prayer is to 1500 to 2000. It cannot exceed
It will
2000.
not exceed.
My lord, let it be, my lord, up 1,500.
That will be
Not 2,000, 1,500.
1500. All right.
Ultimately, সেই মাথা বেড়ে যাবে, কেউ গুনবে না।
Give that location.
Yes, yes.
Entire thing. Please put it in a piece of paper. The exact location. Please show it to Mr. Chatterjee first. Then give it to the court. একটা কাগজ দিয়ে দেবেন ওনাকে একটা সাদা কাগজ দিয়ে দিন ওনাকে লিখে দেবেন The petitioner claims to be the agreed. So these minor suggestions, instead of rejecting, would have solved all problems.
I did it within 15 minutes here.
Both of you have
50% of these matters can be solved.
both of you have agreed. No differences. It could have sorted out,
Could have.
even without the intervention of the court.
That is true. Get.
Yes.
The 7 blood I appear for the state.
Yes.
My lord, the petitioner is the mother who has approached this honorable court with a prayer.
This is that extreme urgent matter which you mentioned yesterday.
My lord, the urgency is that, my lord, she is invoking to Article 226 principally for a declaration that the detention of his minor son is an illegal detention.
That
the detention of his minor son is an illegal detention.
After filing appeal, a statutory appeal under the act.
Very well.
Yes.
You are happy.
Jana, there is a
My lord, may I just
statutory appeal
Yes.
against this.
Yes, already filed. Paragraph
Yes.
17.
Yes, statutory appeal is filed, but my lord, the court is lying vacant. The district judge court is lying vacant there, for which we had to move this honorable court for invoking Article 226.
There is no charge court.
No, the charge
No,
court
no,
is
no,
not taking up the matter. My lord, on affidavit, I am.
No, is there any ever? No, but is there any environment blood that
No,
court is
Mr.
not?
Banerjee, you can take instructions. on
Yes,
that.
I
You
can take
come at-
instructions, but
You can come at 2 p.m.
Yes.
Please take instructions. If the court is lying vacant, whether if there is any charge court, I can direct the charge court to take up that. Please take instructions.
Lordship kindly dispose it of, kindly ask the charge court.
Please take instructions with regard to that. I'm taking it up, keeping it at 2 p.m.
But
Please take instructions.
maintainability of the writ petition. Blood appeal is pending. Paragraph 17, there is no environment as such.
No,
But my
Mr.
learned friend is
Mr.
saying,
Banerjee, I
I
appreciate.
am not seeking
But
bail.
availability of an alternative remedy, it has to be an alternative efficacious. So
that's right.
remedy, providing a remedy in a statute, and if that remedy is not available, so where the persons will go,
But
please
if your
consider
lordship
that.
kindly
because
go through the provisions. There is 2 options. Either learned district magistrate or the learned session judge. There is provision is there.
magistrate,
Yes, he can.
please show me the provision.
My lord, now previously in 2000, the Act of 2000, there is a specific provision of section
101.
52. Now it is 101.
101.
101, yes. Subject to any person aggrieved by an order made by the committee or the board. It's by the board here.
Yes.
Under this act, may within 30 days from the date of such order prefer an appeal to the children's court, except for decisions by the committee related to foster such and such. So provided that the court of sessions or the district magistrate, as the case may be,
Yes.
may entertain the appeal
My lord.
after.
My lord.
So district magistrate is also the can
Hey, Papa,
entertain
yes,
this.
yes,
My
yes,
lord,
given
the
the power.
moment I take out an application for the district judge, in that event, I cannot go back to the district magistrate and take out the similar application. I have
Mr.
all the
Banerjee,
remedies that I have to come
Banerjee,
before
that
this
is also
honorable
there.
court.
If he has 2 alternatives, if he has approached one authority, because
Knowing
otherwise,
fully well the court is vacant. Knowing fully well the court is vacant, lying vacant.
Mr. Banerjee, please take instructions whether
But,
the court is vacant or not. I'm taking it up 2 p.m. Mr. Jana, please, you also take
My
instructions.
lord, my instruction is that the court is lying vacant. There is a charge court definitely,
Yes,
but the charge
definitely.
court is not taking up this matter.
No, I can direct the charge
Yes,
court to take
Yes,
it up.
that will serve my purpose.
Yes,
Even I,
Who is
in
the
that
charge
event,
court? Who is the charge court? Please ensure that. Please, Mr. Banerjee, you also take instructions. I'm keeping it at 2 p.m.
my lord, in that
I'm
event
coming.
also my
No.
review-
I'm coming to PM.
In that event also, detention is illegal, there will be further 3 days illegal detention.
But Mr. Jana, you have approached the appellate court.
Yes.
I have.
Approached the appellate court.
And that is a statement, and that has been stated in paragraph 17.
Appeal is there. So you say that you have approached because
I
the
haven't suppressed anything. I have
No.
managed everything.
No.
Not
He
a
has not
question of suppression. You have said, you have also
That is good for me.
submitted that the court is lying vacant, the court is not taking up. That's one thing. You can approach the writ court. I'm not saying in case of that, but if the charge court is available, so I can direct the charge
My
court
lord,
to
in that
decide.
event, may I just pray, may I make a very humble prayer? My lord, if the order can be communicated today and if the matter can be heard at 4 p.m. now
Today,
because my lord, in any event, the child will be there for another 3 days.
Sir, Jana, today, tomorrow is holiday.
It's holiday for the court. That is why, my lord, else he will suffer another 3 days in the custody. We see, actually, he is not entitled to suffer this. He is not, I use the word entitled, my lord. As per the law, even, my lord, I can
Third
right
Saturday,
now-
third Saturday is open.
Na, kalke open
I think tomorrow it's not open.
Huh?
Tomorrow is second.
Second.
14. Who is instructing you, Mr. Banerjee? Tomorrow is third.
I'll not take the name, my lord, only.
Come at 2 p.m.
My lord.
Yes. Please bring them.
I'm with the state, my lord.
As a respondent, my lord.
I'm the state, my lord.
Yes.
Well, this is a matter relating to the 46 square feet.
Oh, this is a report, my lord.
Shop room, repairing shop room, which has been given by father.
What shop room?
Repairing shop room.
What repairing? What
repairing motor parts, repairing shop room, which has been
lucrative business.
Repairing business.
Lucrative business.
Now, my lord, the said shop room has been given to the by deed of gift to the father of the petitioner to the private respondent. Now, the private respondent, I am the, my lord, the petitioner, which has
petitioner.
But I have.
What is your status in the shop room?
Shop room is the status, my lord. My father already gifted the shop room to the, my lord, the private respondent. My father sold. That is now now the private respondent has now entering into my dwelling house and started disturbance allegedly. And FIR case has been started by the Ashoknagar police station, and thereafter the complaint has been diarized. Kindly see the photographs, how much the mercilessly beaten up to me over the the issue regarding not to dispose from the entire my dwelling house. So lastly, kindly complaint has been lodged before the the kindly come to page. Page 51. OC Ashoknagar police station. Thereafter, my lord, they have also, my lord, lodged a complaint through, my lord, 126(2) of the CRPC before the concerned magistrate. Concerned magistrate, my lord, taken up the matter, and thereafter, my direction to NCO, and thereafter, page 91 was the last complaint to the SP Barasat Police District. That is Ami Alamgir Mondal such and such, that a family body niche amader dokaner স্থানীয় শেখ নাসিরউদ্দিন ওরফে, that is my private respondent hearing, ওরফে বাবু সোনার বাইক গ্যারেজ আছে, ভাড়াটিয়া হিসাবে ছিল আর্থিক চুক্তির ভিত্তিতে, কিন্তু পরে 23/9/2025 তারিখে আমার পিতা আলী হোসেন মন্ডলের নিকট থেকে ডিড নাম্বার সাচ অ্যান্ড সাচ 7/60-42 বর্গ ফুট কার্পেট এরিয়া হিসাবে
gift deed is respect of the shop room where you are carrying on business.
Gift deed is respect of the shop room. Sale deed is respect of the shop room.
Sorry,
sale deed is respect of the I have got the property by way of deed of gift. Rest of the portion, remaining portion, that I will annex the copy of the sale deed as well as the gift deed.
You are saying very small shop room.
Very the 42 square feet. Very small.
42 part has been sold, part has been gifted.
Part has been gifted.
Yes. Now, what is the dispute now?
Dispute now, my lord, that this private respondent entering into my dwelling house.
The dwelling house.
Dwelling house. Yes, remaining portion is my dwelling house. Shop room is the
dwelling house. You are the owner of the dwelling house.
I am the owner by way of deed of gift. My father has gifted to me. So that is, my lord, that they have been written that 4/12/2024 Bela Anumari Taraite.
What the police authorities will do?
My police authority will do, my lord. I have been, my lord, mercilessly beaten up. My lord, I have not been stayed. Lastly, my lord, I may annex the photographs. I am lastly hospitalized. Thereafter, my lord, I cannot stay peacefully in my lord, the dwelling house. They have been, my lord, again and again enter into my dwelling house and
that
take
you
the
have to
issue.
approach the civil court.
Yes.
So that they do not encroach upon your property.
That is the issue. But I have to stay over there, man, peacefully.
You
possession, I have to ensure.
This possession, you have to approach the civil court.
But question is myself asking, but I have to stay over peacefully. I have to stay. That is the police has to ensure.
No
that
breach of peace.
That is the issue.
No breach of peace takes
that
place.
is as your lordship.
Purpose of possession Police
No,
cannot
no,
do anything.
I am not asking for possession, but asking for maintain the peace so that I can stay what they have been enjoying.
No, one thing, my lord.
Police will not maintain the peace.
No, my lord. Yes, my lord. Prior to that, my lord, can I once go through the my lord? On 5th December, my lord, they tried to dispose from my shop, my lord. Regarding that, my lord, they assault me, my lord.
Not going into that.
But another thing is that, my lord, within 5 days from the date of lodging of the FIR, my lord, they filed police in action.
But I have
But
not seen
12
the-
is the my lord, FIR
they
date,
are-
and 17 is the filing the case, my lord, before lordship.
Where is the FIR?
Kali my report, my Kali.
Date of FIR, my lord, page 50, my lord.
Page
Un-
50.
Starts from the my lord.
The complaint. Where is the
Page
complaint?
47.
My lord,
Complaint is my lord, the page 50.
my lord, 44, my lord.
44.
Page 41, my lord.
44 is the
12th December 2025, my lord.
no, 44 is the part of the
Now complaint my lord 51. Kindly come to page 51.
FIR is
44, my lord, page.
12 December.
FIR is in my copy it's 45.
And 51 is a complaint.
So it's 12th of December 2025.
My lord.
Yes.
And copy
lord.
of the complaint is
My lord, affidavit shows, my lord, 17 December, page 15, my lord.
That is the issue. That the question is that
Within, my lord, 5 days.
December 2025 and the complaint has been lodged. Kindly come to page 53. 9 December 2025.
Yes. If arrest on 12 December by the police. On 12.
Another thing is that, my lord, in FIR, my lord, 10% name has been taken, my lord. In writ petition, only
I'm not deciding the FIR.
only private respondent, my lord, 1. 4,
I'm
my
not
lord.
deciding the FIR.
Page 55.
They are creating pressure upon me, my lord, to my lord,
Page
dispose of my
55,
shop, my lord.
The injury report.
Or during that time, I already taken the bail, my lord.
The petition
my lord has upgraded my matter as item 10. But my lord, I have to leave court now for an personal reason. May I do it on Monday? My lord, there's some urgency. My lord has, after much mentioning, my lord has allowed it. I'm very ashamed
You
to
have
ask for
juniors,
this.
competent juniors assisting you, Mr.
Lord, I
Chakraborty.
am the junior most. My lord. May I come back on Monday with this?
But I have
Yes,
taken
Mr.
the
Banerjee, you have
instructions,
taken
blood, ADJ 1.
the Juvenile Justice Act.
Yes. Either 101. Oh. Blood ADJ 1. Your Lordship has directed me to take instructions.
Yes.
I've taken instructions. But Durgapur, ADJ 1 in charge. But the ADJ 1 is vacant. But ADJ 2 vacant, but ADJ 2 is a charge
Because
court.
this statute says children's court.
Yes.
So ADJ 2 has the power of the
Power,
children's
charge
court.
court, yes, charge court is ADJ 2.
Yes, what is your instruction?
And over and above, may I say one thing? Because juvenile court and board is within the jurisdiction of Asansol. There is no juvenile court in Durgapur. Though the cause of action pertains to Durgapur court's jurisdiction, but the juvenile court is one in the Paschim Bardhaman. That is at Asansol. And juvenile board has passed the order in Asansol. I do not know, but they could have filed an appeal before the land session judge in Asansol. But
Whether because the
yes,
statute says
that is why
the children's code. I do not know whether any
children's
they are
no
Asansol
children
are vested with the power of the children's court.
Asansol children's court is lying with the Asansol court, not in Durgapur.
Yes, Mr. Banerjee, what is your instruction?
Well, so far as my lord vacancy of the learned court is concerned, my learned friend has
No, that is in Durgapur.
district judge is not there, ADJ 1 is not
No,
there.
district judge is there.
No, district judge to transfer করতে নেই স্যার ওটাই তো ইয়েটা মানে my lord with regard to my lord the other factors my lord kindly considers this aspect my lord the detention is absolutely my lord perverse. The detention itself my lord
If you want to go to the merits, I will decide it on merits. That's up to
Because
you.
there is a milord,
Then
there is a point taken, milord, is that
if you want to
so far my lord my
to be hard on merits, I
so far
can
my lord my instruction my lord from the client is concerned and my lord my senior
to move on merits.
Move on merits my lord.
All right. Yes.
then he has to cross the hurdle first. But in the appeal, the same blood the points in the appeal 101 statutory appeal, and as well as without exhausting that, he has come before your lordship. Kindly ask my landfill to cross the hurdle.
My lord, Jana, there are two aspects. If you want this matter to be taken on merits, it's one thing, because you have preferred an appeal. According to you, there is no that court is lying vacant.
Yes.
But the court is there.
Charge court is there.
Charge court is there.
Yes,
Charge court is there.
I've taken instructions.
That's one thing. So your argument that there is no forum, that's neither here nor there.
But I have submitted that the charge code is there, but I have tried my luck. My lord, charge code did not take up my application. That is also I have submitted in the morning.
That I can direct the charge code. That's one thing. Now, if you want this matter to be moved on merit, that's another thing. And also you can, because here what you have paid for, you want bail.
My lord, kindly allow me to amend it also.
That order.
That
The order under appeal, here milord order has been challenged.
The prayer at page 23, issue a writ of habeas corpus, it should be issue a writ of mandamus. Kindly allow me.
Where it is? Oh,
and on mandamus. My lord, may I just delete?
And on mandamus you have said. All right.
Habeas corpus, may I just delete it?
Yes, sir. You have said also mandamus.
Yeah,
So
I
I
have
am
also
taking
said.
that you are pressing mandamus, not habeas corpus. Directing the immediate release. So in effect, you are praying for bail.
My lord,
can you not approach the bail court for bail?
Yes,
I have.
That was
When you have a specific remedy available before this court, before the High Court.
No, my lord, may I just inform my lord, the procedure prescribed is that find first any detainee, when a child in conflict with, or conflict with law, will have to take out an application before the board. After if it gets rejected, the appeal has to be preferred with the district judge.
You cannot apply for regular bail.
No. After that only, with the rejection of that appeal, the revision lies. Or a bail appeal 439 previously. Now that is
what I am saying.
Yes.
So you can pay for bail also.
No, not simultaneously, only after the disposal of the appeal.
Why?
Yes, the scheme of the act says so. My lord, may I just
Show me
kindly
that.
see 101? A boy.
No, you want that book? Yes, Mr. Banerjee.
No,
please
I
give
have,
your-
I have. No, I have.
No, yes, your junior has given me. Yes.
My lord, 101.
Yes.
Subject to the provisions of this act, any person aggrieved by an order made by the committee or the board under this act may, within 30 days from the date of such order, prefer an appeal to the children's court except for the decision by the committee related to foster care and sponsorship after care, which the appeal shall lie with the district magistrate. Now, the first limb of submission by Mr. Banerjee about the so far my detention is concerned and my bail appeal is concerned, my lord, this is not the thing, except for the decision by the committee.
439 once. Please show me 439 once.
439 of the CRPC.
BNS.
চেকটা যাচ্ছে আপনি চেকটা
দাও। So according to you, after rejection, bail application, after rejection by the board, you cannot come directly before
to the High Court.
Please
We
show
cannot.
439 once. So according to you, you have to follow this procedure: appeal, after appeal, revision,
or bail. I can. Both the order are there. My lord, I can directly take out an application
So
for
bail,
bail
according to you-
challenging the order passed in the appeal. My lord, similarly, the provision is there in my lord National Investigation Agency Act also.
Please show me that. It's not according to it, it's not concurrent. So
No,
you
no,
cannot.
not concurrent. Like 439, the concurrent jurisdiction lies with the district court as well as this honorable court.
Yes.
Well, for which the other reason is for making this a single bench. My lord, this is also another reason the concurrent jurisdiction both are having.
Yes.
Here, the concurrent jurisdiction is not lying with
Please show
any
me
court.
439
There is
once.
no.
What's the language of
No,
439?
430. Here, the provision is in BNS 483.
I think the provisions with regard to the bail is that has not been changed. The substantive provisions has not been changed.
Only section.
Only the section.
So,
If you have the C, also rely from there.
my lord, I have. হ্যাঁ 483 হাই কোর্ট এন্ড এটা একটু দেবেন মাই লর্ড
483
483 subsection 1 my lord এটা বল left hand side.
Yes.
A high court or a court of sessions may direct that any person accused of an offence and in custody to be released on bail, and if the offence is of the nature specified in subsection 3 of section 480, may impose any condition which is considered necessary for the purpose mentioned in that subsection. Thereafter, my lord, that any condition imposed by magistrate when releasing any person on bail be set aside or modified. This is relating to modification of the order of conditions by the magistrate.
Yes.
Provided that the High Court or the Court of Session shall, before granting bail to a person who is accused of an offence which is triable exclusively by the Court of Session, or which, though not so triable, is punishable with imprisonment for life, give notice to the of the application for bail to the public.
So after hearing the public prosecutor, this has to
Only.
be done.
This is therefore, my lord, the concurrent jurisdiction so far this act is concerned, my lord, this provision is not like. Now, my lord, may I just, if your lordship wants me to address this honorable court on merit, my lord, this petitioner is claiming that the detention is illegal. My lord, after if I can satisfy this honorable court, my lord can direct only. Me, my lord, consider. My lord, kindly sees what is the allegation here. Page 27. আমারটা কোনটা? Page 27.
Yes.
My lord, the FIR was registered pursuant to a complaint made by Jafar Imam. My lord, it is just page 28. In nutshell, may I just inform this court? My lord, Jafar Imam, he is a businessman having a business which is named in the style of Mrs. Jafar Imam Creation. Now, he entered into an agreement with one Iron Enterprise. Iron Enterprise is a proprietary business body where my father is the sole proprietor. My father. Now they both entered an agreement by which the iron enterprise agreed to sell machine sheds, electric items, wire cables, function machineries, factory sheds, scrap of iron sled, including forfeit, whatever. But all these items, they have agreed that these items will be sold by my father to the complainant. To that effect, the complainant transferred an amount of 1 crore to the bank account of my father. My father allegation is that did not supply those articles to the complainant. He came to my father. My father thereafter issued 2 checks amounting to rupees 49 lakhs 500 and 49 lakhs 500. Both the check got dishonored. My lord, he otherwise initiated procedure 138. Now he sent a legal notice to my father, the iron enterprise. After that,
were issued by your father?
My father, the iron enterprise. No, because of this, the entire lease is between the iron. My father is the proprietor of that one, and the complainant.
No, I'm asking you why your father issued these 2 checks.
Sell
because there was a sale. You are entitled to. Your father was entitled to 1 crore. Why did he issue another check?
He has paid an advance amount of 1 crore to my father.
Why did you refund him? Why did your
because
father
I could not sell those documents.
Why you could not sell those properties?
My lord, because there are certain reasons. The lease is there. Now, my lord, the lease between the
What is the
parties.
reason why you did not? Why you could not sell those properties?
My lord, may I just? My lord, kindly comes to page 29 once.
29, yes.
In the of the letter of complaint.
Yes.
Based on agreement for sale, data.
Third sentence from the top.
Yes.
They showed me an alleged agreement for sale of
Page
plant
29.
and machinery.
Page 29. Yes, they
Page
showed.
29.
Yes.
My lord, third sentence.
Yes, I've got that.
They showed me an alleged agreement for sale of plant and machinery. My lord, this is what the allegation against me. By producing this document, my father has obtained 1 year from the complaint.
Yes.
This is the allegation. Now my father failed to sell those documents or transfer those articles to the complainant in spite of the advancement made by the complainant.
I'm asking you why your father failed. You must be knowing that.
My lord, my father failed because, my lord, my father did not get those articles. My father is the middleman between the 2 factories. One who intends.
You must be showing some documents pursuant to, because 1 crore is not a matter of joke. You must be showing some documents in support of thing that you can transfer. What were those documents?
My lord, this is the sale agreement only. This says we have. My lord, this is the claim. My lord, I am not praying for termination of the proceeding. My lord, may I just say this? I am not praying for termination of the proceeding, nor I am praying kindly go to the merit of the case.
The thing that you have issued 2 checks
My
shows
father.
that, yes.
My father, not me.
Why you have been implicated?
Yes, that is the thing I am saying, my lord. My lord, for once kindly comes to page 28.
Yes.
My lord would find I, Jafar Imam, partner of Jafar Imam Creation, residing in Kolkata, submit that this formal complaint seeking immediate registration of an FIR and necessary criminal action against 3, middle name Mr. Mohammed Ayan, son of Muhammad Arif. I am a juvenile, 17 years old.
Yes.
Now, thereafter he says, he himself dictates what we have done, that deliberate cheating and all. My lord, next internally, that Iron Enterprise has purchased the factory assets of KB Sponge Iron Private Limited.
Yes, so you have purchased.
Of the KB asset, now I agreed to sell all those articles to him, for which I took 1 year from him as towards advance. Thereafter, I failed to give those articles. Now, anyway, well, I failed. I admit, I have taken this amount from him. I issued 2 checks in your favor. Well, that is also admitted in the letter of complaint. Both the documents, both the instruments got dishonored. He initiated procedure under 138. Thereafter, he again issued a legal notice. Those are all admitted facts. After the legal notice, my father made a part payment of 5 lakhs. Now the remaining due is 95 lakhs, for which though he has initial position 138. Now my name transfer here only.
Have you served Jafar Imam?
Jafar Imam service? Okay. My lord, I have sent it, my lord. একবার দাও। Review service টা দাও।
They have delivered, received.
No, received. Not received. My lord, they can be notified through state also. My lord, I am not on that. I am not praying for termination. Neither I am praying the my lord can look into the merit of this.
They do not have any right to oppose your prayer for bail.
Never. My lord, why I tell you, lordships? My lord, before 2015, subject to correction, before 2015 Act, there was the Act of 2000, Juvenile Justice Board Act. My lord, the principle which was actually uttered by my lord Justice Krishna Iyer, that bail is rule, jail is exception, that was truly followed in JJ Act only. Juvenile Justice Act. Wherever a person is arrested who is found a child in conflict with law, my lord, court is supposed to, the board is supposed to grant bail to that person, the juvenile. Now, my lord, after an heinous offense committed in Delhi, my lord, which is otherwise known as Abhaya case, my lord, there is a change, complete change in the act. A new provision has been introduced in the act, which is called heinous crime. My lord, this is principally for the purpose for the board to assess the mental age of the person who claims himself to be a juvenile. Now, my lord, the other reason is that if a person who is below 18 years but is understanding of the consequence of the crime is there, in that event, my lord, he should be tried like an adult. This was the principal purpose. And my lord, for this reason, before enactment, my lord, during the debate, my lord, it was category
ground on which it was rejected.
Yes, my lord, kindly comes to that.
Yes.
Kindly comes to that. My lord, before that, may I just take your lordship once, after this, once to page 30, my lord, 5.
35.
5,
Yes.
1. My lord, now this is an order passed by the addition by the session judge at Paschim Medinipur while dealing with Bardhaman, while dealing with application for PRS bail of the father. Now, my lord, where the case diary was produced, my lord, for once kindly comes to page 36.
Yes.
My lord, hard learned counsel for the parties. Thereafter, the observation. Peruse the magistrate court's record and material in the case diary. Case diary contains several letters exchanged between one, Jafar Imam, the complainant, being de facto complainant, Iron Enterprise, which the accused persons are partners.
Accused persons.
Persons is me, my father, and the other number 3. My lord, the middle name, number 2 is me in the complaint. They both approached.
Yes.
Although the case diary contains several letters exchanged between the accused person and the de facto complainant, case diary does not contain any agreement or contract indicating that there was any agreement entered between the parties for supply of materials and purchase of materials. However, as per averment made in the FIR itself, it appears that 2 checks were issued by the accused person of 49 lakhs each, but both the checks were dishonored. The legal notices have been issued against the accused persons, giving indication of initiation of proceedings under 138. From the material in the case diary and the averment, it appears the dispute between the parties purely civil in nature, arising out of a contract. My lord, this is the observation made by the learned sessions court at the time of grant of PRS bail. My lord, after these observations, kindly comes to page 38, the accused persons were granted bail, PRS bail. Now, my lord, me the juvenile, my lord, I surrendered. My lord, may I just take your lordship wants to annexure P4, my lord, at page 52. 52.
Yes.
52.
Yes.
My lord, this is an order dated 10th February 2026.
Yes.
On that day, I surrender, the juvenile surrender. My lord, the scheme of the act says, my lord, may I just for once kindly take your lordships to the act itself.
Yes. Yes.
My lord, may I take your lordship to section 7?
7, yes.
Now, my lord, the juvenile, he surrendered before the board.
Yes.
Now, my lord, section 7 of the act says what is the procedure to be adopted by the board. The board shall meet as such times and shall observe rules in regard to the transaction of business at any meetings as may be prescribed and shall ensure that all procedures are child friendly, and this is all there. My lord, then the child in conflict with law may be produced before an individual member. My lord, board consists of 3 persons, generally one by the principal magistrate and by 2 social activists. Member of the board, when the board is not sitting, board may act notwithstanding the absence of any member of the board, and an order passed by the board shall be invalid by the shall be invalid by the reason only
So
of
lack
the
of quorum will not be.
yes. Now, my lord, provided there shall be at least 2 members, including the principal magistrate, present at the time of final disposal of the case on making an order under subsection 3 of section 18.
Yes.
Now, my lord, this order was passed by the principal judge of the board.
Yes.
Thereafter, section 14. My lord, kindly comes to the other provision. My lord, section 12 deals with the bail application, which I have taken out. That is now, my lord, section 14.
Yes.
My lord, section 14 says, my lord, where a child alleged to be in conflict with law is produced before board, the board shall hold an inquiry in accordance with the provisions of this act and may pass such orders in relation to such child as it deems fit under section 17 and 18 of this act.
Yes.
Now, inquiry is the essential requirement. Number 2 says, the inquiry under this section shall be completed within a period of 4 months from the date of first production of the child before the board, unless the period is extended for a maximum period of 2 more months by the board, having regard to the circumstances of the case and after recording the reason in writing for such extension. Then 3, a preliminary assessment in case of heinous offences under section 15 shall be disposed of by the board within a period of 3 months from the date of first production of the child before the board.
Yes.
Now, my lord, the term heinous offence which has been incorporated in this act, my lord would find it in section 3, section 2, section 2, section 33, the definition chapter.
Yes.
My lord, 33 says heinous offence. Got it? 33.
7 years or more.
Yes. Includes here, my lord, lies the, my lord, this is the crack of the entire thing. My lord, any other law for rhyming force is imprisonment for 7 years or more. Therefore, the minimum punishment prescribed is not 7 years. The maximum punishment is 7 years. That is what it says. Sorry, minimum is 7. It can go up to this.
Yes.
Now, my lord, 14. This is 14. My lord, kindly comes to, my lord, I shall place this order. My lord, kindly.
Dana, only one thing before you proceed further. The latest information is that 11th your matter has been fixed in ADJ second court of Asansol.
11th?
11th of February.
11th of February. But court was not there. 11 was appeal was filed on 11.
Date was fixed on 11th.
আরে মাইলটের কাছে তাহলে information is the 10th is the impugn order passed.
It was fixed. Second court, second ADJ at Asansol.
Oh, my lord, I have annexed that also. My lord would find it page 63.
Lord,
What happened on that date?
and over and above, my lord, but subject to your lordship's kind consideration, whether your lordship is having the determination of hearing of this matter. This is not police inaction or overaction. He challenged the order. This is residuary.
Group 9.
Group 9.
Group 9 assigned urgent matters. They have
No, Group 9 police in not Group 9 is there. Krishna Rao, Justice Krishna Rao.
That's bench is not available for which it has been assigned.
Justice Krishna Rao is sitting today.
Residuary group 9 is different. Police in action.
Police in action. Subra Ghosh.
Justice Honorable Justice Subra
Subra Ghosh.
Mr. Jana.
Krishna Rao is sitting. And residuary and four. Yes, this code is not having the determination.
Take up that. If it
Eta.
does not fall within Justice Ghosh's determination.
Police inaction or not overaction, it is
not police inaction.
Residuary Krishna Rao. Justice
No, I do
Krishna Rao.
not know the determination of Justice Ghosh. What is the determination of Justice?
Inaction or no inaction.
Then
Justice Krishna Rao is residuary. We are regularly appearing. No. তিনটে চারটে ভাগ আছে না
police in action only.
Justice Subra Ghosh. Court number 25. Residuary group 9.
It also did not click in my.
My lord.
Available time of. Do not know anything.
Your appeal can be
that I will not
Monday or Tuesday.
I will.
My lord, now I have no other option also.
I will not
Because now I cannot go back to the other court right now, my lord. This is the logistic problem is there, my
I can
lord.
try that, but in a different capacity,
My
not in this.
At least the appeal can be heard. আজকাল আপনি কিছু করতেই পারবেন না।
One thing, Mr. Jana, please keep a contact in that court. It may be taken up either Monday or Tuesday.
My lord, my apology, my lord. I should not have wasted this time.
Yes, call the next matter.
I'm deeply obliged, your lordship. সকাল থেকে বসে রইলাম লাস্টে
Yes.
Very inception, I requested Mr. Banerjee to draw your lordship's attention, however.
Yes, what is this matter?
My lord, this is my application, my lord. My lord, I have made complaint against my husband and father-in-law that I
Lord,
was
before he argues,
Husband, father-in-law.
My lord,
Lord, before he argues,
Please stay.
my lord, I am
Lord,
staying.
before he argues, what is the urgency in this matter? For us, on the urgency basis, it has been
There is
mentioned.
no urgency.
Yes,
There
my
is
lord,
not
actually,
an urgency.
is that
FR has been
because
lost.
I'm staying
FR
at
has
my
been
in-laws' house
lost.
regularly. My husband has not been granted bail. He is roaming freely. Police has not taken any action, lordship.
How do you
And
say it?
Plain registration of the FIR done on
Two
when
persons
the
have
FIR
already
was
been granted
registered.
bail.
My
Two persons granted bail, another person.
on me, my lord.
There is no urgency in this matter.
There, my lord, and
You cannot
I'm,
wait till 1 week.
my lord, I'm staying at my in-laws' house, and they are kindly come to my complaints, my lord. I'm staying there in my house, and regularly they are I mean, threatening me, and the police is not taking any action.
My lord, your lordship, kindly come to
Me and my daughter.
page 41 is the complaint, my lord. Page 51. 41 is the complaint, your lordship, my lord. I will not read it out. এক মিনিট, brother, I will not read it out.
Sir, আমার তো application, আপনি দাঁড়ান, আমায় বলতে দিন একটু।
Yes.
My husband is roaming freely, my lord. His bail has been rejected, lordship. And police are not arresting him. He's staying in the locality. Police knows everything. And when I'm going to police, the police
All right,
refuses
file a
to take
report
action.
with
My lord, I am handing you the report.
Yes, what's
Your lordship, kindly see that. FIR has been registered, not two persons have been already granted bail. They surrendered,
no,
and
he
then one
said
person
that,
is
their prayer has been rejected.
My lord.
rejected.
Whose prayer has been rejected? Prayer for
Bail has been rejected, my
what
lord.
happened to that?
My lord, your lordship, kindly before that, your lordship, kindly come to page 41.
41 of the
Page,
repetition.
read petition. Your lordship, kindly see. I will not read it out. No, because I will not. Your lordship, kindly see that.
All right.
The allegation against mainly against the father-in-law. Your lordship, kindly see from the middle portion. I won't read it out.
My lord, this is not against only the father-in-law. The incident is against father-in-law, but the entire thing, husband has remarried, my lord.
Remarriage means what the read court will do.
Made private respondent.
What the read court will do if the husband has remarried?
Police is not taking any action against the husband, my lord. Husband is
Nothing there.
freely in the locality. Husband's bail has been rejected, and he with and I
Your lordship, kindly see.
plotted at my in-laws' house, my lord, where the husband and father-in-law stays. They are regularly
Even IO has, my lord, IO has,
discusses me and throwing me out, lordship.
IO, my lord, requested the petitioner to take the Sridhan. She has refused it.
Ashun, the petitioner.
My lord, for respondent number 5 to 8, my lord.
I am appearing for.
I beg to.
Wait till Monday.
My lord, let the maintainability point then be kept open.
I'm not doing anything. I'm only keeping it for Monday.
My lord, very well, my lord.
Not today.
Grateful.
Next.
Grateful.
Monday.
Please.
My lord, same order as your lordship passed in this item number 9. Same case.
Same case.
Similar matter, because my lord, in my case,
Monday. Not today. Next.
For item number 12, I'm for the petitioner. My lord, Monday.
Not today. Next.
Much pleasure.
Not today. Next. Monday.
Honorable Ganguly is appearing in a short passover, my lord.
Monday.
He's on his way.
Not today. Yes. Next. All the fixed matter.
40.
Not Monday. Yes. Yes.
May it please your lordship.
Sorry, Mr. Basu, I'm late by 10.
Kindly do not put me in embarrassment. Millet, I say, Millet, I apologize, Millet, whatever Millet consequence and inconvenience that my lord was put into. And my lord, I know my lord would not take me amiss, but still it's I am my lord's officer, my lord. And being a poor my lord, lawyer, my lord, I had to maintain my lord, both the matters. Somehow I could not manage yesterday.
Mr. Basu, the difficulty is with regard to fixing a particular
Lordship,
time.
lordship. My lord has fixed on on a
Not
previous
the
day.
pressure of this side.
I know.
That's the only difficulty.
Fine.
So in this type of contested hearing matters,
My lord,
if you
absolutely.
do not
But on the
adhere to
other day,
time
lordship
limit,
has
it's very
fixed the prior, my lord, on a month of January. When my lord, I was appearing in the last week, my lord, before the Honorable Supreme Court, I said that I have a fixed matter. But somehow, my lord,
These
they have
matters,
kept it yesterday top of the
parties have to make alternative arrangements, Mr. Basu. Otherwise, it's very
my
difficult.
lord.
Yes.
For poor lawyers, my lord, losing, my lord,
Different thing.
now, my lord, before I take you,
That
lord,
does not apply to you.
Yeah.
Maybe to others. Yes.
so it may not apply to Mr. Rai. He doesn't bother.
Yes. Start.
Now, my lord, before I take your lordship, my lord, to the legal aspects, well, may I just give you a very rough backdrops? There I'll take you, my lord, to the details of facts. My lord, according to me, my lord, or my understanding, the private respondent is an interloper. He initially lodged a complaint that there are certain constructions made by the local body which, my lord, obstructs its ingress and egress. Now, my lord, a complaint was made before the Public Works Department, Government of West Bengal. And, my lord, on the basis of having complained that it causes ingress and egress, a proceeding under 10(1) was initiated. Subsequently, my lord, proceeding did not proceed further. What are the facts on record? They came up by a 226, where this honorable court, a coordinate bench, said that there are allegations of encroachment, having constructions, let the report be called for or whatever the special officer be appointed. And after finding, well, having a special officer report, the honorable, since it's a 10(1), so it's not High Court could not have come to any finding without the fact finding authority come to certain facts. And the 10(1) proceedings, so the honorable single judge, in a simplicity, directed the authority to proceed or initiate a 10(1). There was an appeal against it. Now, in appeal court also, the same allegations which was there in the single bench, that it obstructs my ingress and egress. The honorable division bench said very well, the honorable single judge has simply directed for initiate a proceeding under 10(1). So let the proceedings be initiated. And there are certain passages also where it says that it is admitted. Now that was a prior to 10(1). It is admitted, certain, etc., etc. Now I will come to that part also. Now the 10(1) proceeding subsequently, my lord, followed up after the division bench order. And in the 10(1) proceeding, my lord, they considered, my lord, a report filed from BLRO and said, my lord, that BLRO report speaks of that there are encroachments, alleged encroachments from both the sides, from the local body as well as from the private respondent. Then, my lord, a direction was made upon us. I do not know about them. I will also see, my lord, that to remove my encroachment. Thereafter, nothing was happened. My lord, then
the 10-2, the authority, my lord, under the 10-2 SDE, subdivisional my lord, officer, he, my lord, passed an order. Now, my lord, against that, an appeal was preferred under 10-3. Now, my lord, there,
10-4.
10-4, I stand corrected, 10-4. Now, my lord, in the DM proceeding, the appellate authority proceeding, my lord, there was a, since it is their allegation that ingress and egress, and that is the root of cause of action. The ingress and egress was being blocked. So the BLRO or other authority was directed to see the whether there was at all any obstruction or not. And the report came, say that there is a widest passage, no ingress and egress obstructions. The allegations are absolutely unsustainable. All on a sudden, now they changed their stand. They came up again filing a writ petition before another coordinated bench, say that so far as the West Bengal Highways Act and the inquiry to be conducted in under the provisos of 10 does not require that whether it obstructs my ingress and egress. So original what was the root of cause of action, they subsequently changed it. The Honorable Singh just said very well, as per the act, it is not there, so DM will not also look into it. Then DM in terms of the order, passed or affirmed the order for removing of my encroachment. This is the facts I will show. Now, prior to that, may I just indicate to your lordship, one particular aspect, the Government Buildings Act 1899. And there are two judgments. One by authored by Honorable Justice Jyotirmay Bhattacharya, but my lord was sitting as a Chief Justice of this court. It relates to the construction made within the vicinity of this High Court. Your lordship is aware, my lord, the inside of the main building, there was a litigation where also the allegation was made that this High Court was constructing, making some constructions in violation of the law. Now, kindly before that, I will take your lordship the Government Buildings Act. Copy ta deben. Now, before looking into that, my lord, kindly also takes, my lord, the opposition filed by the respondent number 4, just to have a look. Opposition filed by the respondent.
Proceed with the act.
Yes, well, I will proceed, but the same point also taken by the respondent number 4. That is what I intend to show.
Which point?
This Government Buildings Act.
All right, that will show. Please come to the law point.
The Government Buildings Act 1899, if your lordship see, my lord, it's an act to provide for exemption from the operation of municipal building laws of certain buildings and lands which are the property or in the occupation of the government and situate within the limits of a municipality. So, my lord, the act, for what purpose it was enacted? To provide for exemption from the operation of municipal building laws of certain buildings and lands which are the property or in occupation of the government and situate within the limits of a municipality. Whereas it is expedient to provide for the exemption from operation of municipal building laws of certain buildings and lands which are the property.
So according to you, the municipal laws shall not operate. There can be exemption.
Now, my lord, may I just also read further, my lord?
So any section you are trying to rely upon
My
in this? Which
kindly comes to, my lord, section 3.
Yes.
Exemption of certain government buildings from municipal laws to regulate the erection of buildings
So
within.
according to you, the impugned construction does not require the municipal sanction.
My lord, this law, it is section 3 says only an intimation is to be given to the municipality. I show that. Only an intimation.
To the municipality.
To the municipality.
Municipality will construct, municipality will give intimation.
Now, my lord, here what section 3 says, my lord, may I just read it?
No, I am asking you. Municipality will construct, municipality will give a notice to municipality.
No, my lord, it doesn't say, my lord, anything about construction of a municipality in particular. It says whatever be the constructions.
That is in your case.
My lord.
Section 3 applied to your case would mean municipality will construct by giving an intimation to the municipality.
My lord.
That's
because he is the he is the body.
All right, I follow that. For that, you need not place the entirety of the section. I have followed that.
Now, my lord, may I just read, my lord, this particular part? Nothing contained in any law or enactment for the time being in force. Nothing contained in any law.
Non-obstantive clause.
Non-obstantive clause. And my lord, it says of any law.
Prevail over all other laws.
All laws.
Yeah, please. Follow it.
Even other than municipal laws also. That is what I say, but nothing contained in any law or enactment for the time being in force to regulate the erection, re-erection, construction, alteration, or maintenance of the building within the limit of any municipality shall apply to any building used or required for public service or for any public purpose. Well, I stress on this point. Well, the constructions which are made, it is entirely for a public purpose and for a public service. I am a municipality. Even the municipal laws provide, my lord, which are obligatory. My lord, Lordship is aware, my lord, West Bengal Municipal Act. There are certain parts which are in division and some parts which are obligatory. So my obligatory parts, my lord, I maintain a Shulab complex, a Shauchalaya for the, my lord, the benefit and enjoyment and welfare of the people who are usually coming there in a heart.
It can be on a private property also.
Well, it can, it's a government property.
No, where does it say?
May I say?
It does not say government property. Any property municipality can do that.
No, so far as this act is concerned, this act says on a government property. I am not on other part.
So on any government property, any authority can do, municipal laws will not be applicable.
No, may I say
That's
this?
your interpretation of this statute,
No,
Mr. Basu.
no. My doesn't interpret.
So any
I
government
was also permitted to make constructions.
No, that's a different on facts. So your argument is to be accepted, then any government authority, I'm not saying municipality.
May I add this? Municipality,
Property of any other government authority.
municipality is also a government, is a self-government in terms of Article 243Q.
Basu, that's the difference. So that's the logic flows from all your arguments is that any government authority can construct on any other government authority's property without any permission. That's the sum and substance.
No, I didn't say that without permission. Now I just put a rider over here, my lord. It cannot be.
Municipal laws does not apply. So no permission is necessary.
No, of course.
That is why.
Of course.
So without.
Now, my lord,
Yes.
Now, my lord, municipal laws doesn't apply. Now, what is required? Only a plan is to be given to the municipality. Well, that is what this act says. My lord, act says what it is, and my lord, we only, my lord, are here to interpret subject to correction by your lordship. Now, my lord, here, my lord, shall apply. My lord, may I just qualify this? It requires certain, my lord, specific parameters. Shall apply to any building used or required for any public service or any public purpose, which is the property or in the occupation of the government. Which is the property or in the, so it doesn't even require that it has to be a property. It might be in occupation of the government also. Or which is to be erected on land, which is the property or in the occupation of the government. Provided that where the erection, re-erection, construction or material structural alienation of any such building as aforesaid, not being a building connected with defense or a building, the plan or construction of which ought, in the opinion of the government concerned, to be treated as confidential or secret is contemplated, reasonable notice of the proposed work shall be given to the municipal authority before it is commenced. Well, it doesn't say any other thing. Well, we have to read in between the lines and the enactment and the purpose and the purposive of the act. And we have to
only interpret that.
We only interpret. And it is also not that possible. It is also not there, there are or more than two different interpretations would come or different interpretation. Because it says that the constructions has to be made for a public service or for any public purpose.
Yes.
Now, here, may I also, show that this yes. Now, on the basis of this, now kindly takes up the opposition filed by the respondent by the
you are trying to cite some decisions.
I am so, but before that, kindly, because this is my first limb of argument. I have some other 3-4 limbs, but this is my first limb.
What are the points, please, if you can?
My first
your point so that it will.
My first point of one argument would be that in so far as the Government Buildings Act 1899 is concerned,
yes,
and so long it prevails and operates and holds the field and is held to be a good law.
Yes.
Now, this Highways Act or my lord, any operation of this act will not apply in my case. Because this act is a special act, this is a central act, it prevails over any law. Even if the West Bengal Highways Act says otherwise.
Yes.
Now, my lord, my second point of argument would be that I made a construction on the basis of an explicit promises and assurances given by the authority concerned.
Promissory estoppel.
And I raised construction not a very, my lord, or a few times back. It constructed, my lord, or the original construction made in 1988, the permission was
Who
given.
has assured you?
PWD authority itself.
All right.
Now they cannot, my lord, turn back. The promissory estoppel, my lord, is held by the Honorable Supreme Court. Lordship is aware, my lord. I have brought the judgment also that it also applies to the state. And I myself, my lord, apart from a local body, falls under Article 12. I am also a self-government. I am also a government.
What is the other point?
The other point is, my lord, the state being a welfare state. My lord, so far the obligations of a welfare state is concerned, it's a public, because the act itself says a public service for a public purpose. Kindly read along with the constitution, Article 33, 34 onwards. Because I am also a government. I got the permission. Now, this welfare of a public cannot be construed or cannot be thrown away for mere convenience of an individual, where original allegation is is obstructed by ingress and egress. If the constructions is allowed or is directed to be demolished, my duties which are, my lord,
so your duties will prevail over the inconvenience
not,
of
not my duties are alone. Also the PWD, because they have assured, they permitted me. And the inconvenience, kindly mark it, my lord.
petitioner of a private party.
Now, inconvenience to the extent ingress and egress. I repeat, my lord,
Yes,
on factual
inconvenience-
aspect.
Yes.
But all on a sudden, on a second round of litigation, he appeared with double standard. He said, no, forget about ingress, egress.
Yes, what is the other point?
My fourth point is this West Bengal, even my lord, upkeeping, apart these other 3 points, this West Bengal Act also, my lord, has a saving clause.
This Highways Act.
Highways Act.
Which section?
My lord, section 26. Well, may I come back after your lordship division bench is over?
Section
26.
26.
Well, I am here. Man. I'll come back after your division bench is over. No, I knew, man. I don't want to. And up to whatever, man, your lordship is willing to hear me, man, I will.
How much time it will take?
Man, I do not have, man, much more, man, understanding, man.
I'm asking you how much time it will take.
Your lordship permits, my lord, maybe for an hour.
Right.
And if it permits, my lord, today itself, I would conclude. And thereafter, my lord, if lordship permits, my lord, I will file also a notes of argument, subject to what they say, my lord.
Yes, yes. The division bench.
No, my lord.
There was an agreement. Subject to that,
No, I
I
am here. I am here. Now we are coming to mention one matter, especially assigned, assigned matter.
This bench.
Yes, yes. The 2nd February we have mentioned it was allowed, but it didn't came.
Regional side.
Appellate side. Appellate side. Appellate side.
Appellate side, all right. একটু দিয়ে দেবেন, appellate side.
My lord,
Yes.
my lord, we took out an application for review.
Review.
Review in respect of, my lord, a judgment passed in appeal from decree by Justice Shunji Banerjee as his lordship, as he then was, and my lord Justice Hiranmoy Bhattacharya, my lord, which was, my lord, dismissed for default because
Dismissed for default.
which
So
was
this is a restoration application.
restoration application, but my lord, I had to come, my lord, because we are doing this matter, my lord, against the decree passed by the learned single judge under Order 12 Rule 6, my lord. That appeal was made before your lordships. So your lordships affirmed that judgment of the learned single judge, and my lord, an SLP was taken out, which was summarily dismissed. So my lord, as your lordship knows, my lord, Doctor.
No merger.
That's right. Now, my lord, your lordship knows, my lord, that Kunai Ahmed and state of Kerala, plethora of judgments came. Very recently, last year, there was a 3-judge bench decision authored by Justice Dipankar Datta, which said that not even summary dismissal of the SLP, but even when the Supreme Court has passed a judgment at length, but that is vitiated by misrepresentation and of facts and fraud, then the doctrine of merger does not apply. So, lordship knows the law. Now, my lord, so my lord, we took out 2 applications here because there are 2 judgment debtors. We are judgment debtor number 2. The judgment debtor number 1, according to us, my lord, he colluded with the decree holder, my lord, in getting this collusive decree passed. That is our allegation. So, my lord, we took out 2 applications, one under Order 47 and the other is under Section 47. Now, my lord, the Section 47 application is still pending adjudication.
That's before the executing court.
That's right. Now, my lord, lordship will kindly now turn to page 10 of this application. That is my lord's order. That was precisely, my lord, I wanted to come to. Page 10, Annexure A.
This is dismissed for default.
Default. Now, my lord, in the first paragraph, kindly just see
The order under review. ওইটা কোথায়? ফাইলটা আছে?
My lord, see my এটাতে মার্ক করা রয়েছে, কোনো মার্ক বিনা মার্ক করা নেই আপনাদের কাছে?
That will help us, Mr.
Okay, very well. My lord,
mark the portions which are against you, which are in your favor.
My lords will kindly not mind. My lord, this may not be appropriate to give my lords.
না, এটা নয়। আমি বলছি order under review. The review application, not the application for restoration.
My lord, the memo of review is there.
ও আচ্ছা। ওটা দিয়ে দিন।
Review is there, my lord, but
Let us hurriedly go through this.
and my lord, what has subsequently happened, my lord, there are subsequently certain, just after filing this review, preferring this review, my lord, then certain things had happened. We, my lord, made a search of the sub-registry office and other and some other places, and startling revelations, my lord, cropped up. We found, my lord, that may I just give your lordship then a short.
Please give us 2-3 minutes.
Yes, sir. এই আমার ব্রিফটা তো দেখি। আচ্ছা, ওই
I was represented before when the main appeal was heard, and I was represented by before the learned single judge also.
Yes.
But that possibly, my lord, does not, my lord, negotiate with the idea of fraud being practiced upon this honorable court. I'll tell you, my lordship, why. Now, it so happened.
Have you served? Who is for the other side?
Now, my lord, the other side
of this application.
other side on their own, my lord, appeared the last day. We have served also. We have served also. We have filed. You have filed the affidavit of service. We have filed affidavit of service also.
On the last occasion, they appeared.
Yes.
Today, they are not appearing.
I don't know, my lord. And my lord, it other side, my lord, who on the fourth line of my lord's order, my lords have recorded that the other side submission that the order under review has already been implemented. My lord, the section 47 application is still pending. It's being hard extensive.
Submitted that.
That's right. So that is what I say, my lord. That is precisely how, my lord, the decree.
Neither here nor there, implementation or no implementation. This was only dismissed for
Default, absolutely. Dismiss for default simply sitter. But what I just want to harp on before your lordship,
They have only recorded their submission.
submission. But this is precisely what has been misrepresented before the court time again and again and again. I have all documents to show your lordship.
Every service file.
By the 11th of March, by the learned single judge. My lord, may kindly will not give. I know how hard pressed your lordships are, and this is an irregular combination of my lords.
That's the problem.
But my lords, may kindly will not. I will take only 30 minutes time, my lord, to show.
At order.
Another small thing, my lord, as I was reading this application for stay, which was filed GA number 1 last evening, my lord, I felt it was not very happily drafted. So, my lord, may kind withdraw and file another application for stay in the meantime, before your lordship takes up the matter on the next date.
তাহলে stay as well as the review or only the review?
কি লিখেছেন? Restoration at Millard only because only the review no, the review application stands dismissed for default. My lord, it was not mentioned that the GI in connection with the review was also dismissed. It was not formally.
The main matter goes.
Yeah, absolutely, it also goes. So, my lord, in place and state of that application, a new application.
Technically, the stay applications to revive.
Revived. Well, Lord, only in place of that, a new stay application will, because I must be clear to my own conscience that I must be in a best position to assist your lordships.
You can apply the provisions of the civil procedure.
My lord.
To know what can be done in such a situation.
My lord. That these days the Honorable Supreme Court has become more of a 142 court rather than 141 court. But I am not.
No comments from.
Yes, I am not. I am also not. But only thing is that my lords always have that inherent power, and my lords. Well, for this small thing, because if I am given that liberty to file a fresh petition.
But in their absence, Mr. Chakraborty, let them come. What is the defect in this stay application?
No, there's no defect. Only thing is that possibly it could have been drafted better and more documents could have been annexed with the.
Can accept that documents for that you don't.
Very well. Grateful, my lord. Grateful. Appearing before lordship. Okay.
Lordship, for the petition, Your Lordship, this is a contempt application. Page number 84 is the original order against which I have filed a contempt application, Your Lordship. Kindly turns to the operating portion, page number 85. Order dated 27 November 2024.
Yes, Mr. Ghosh.
Lordship,
yes.
Thereafter, what happened, Your Lordship? Thereafter, subsequently, on 22nd September 2025, Your Lordship, this matter was again taken up, and Your Lordship, the time was extended for some 3 weeks, Your Lordship. Thereafter, Your Lordship, and liberty was given to us. Lordship, can you take the order, if Your Lordship have the order?
Order dated?
2nd September 25.
Yeah, 2nd September or December?
September, Your Lordship.
Yes, 2nd September.
Your Lordship, it is stated that, Your Lordship, last page, page number 4, time has been given, and thereafter, Your Lordship, the applicant is granted time to revive this contempt application by filing appropriate, if necessary, relief, Your Lordship. Thereafter, one application for GA was filed, and this honorable bench, Your Lordship, on 2nd December was pleased to revive this application, Your Lordship.
Yes.
Now, Your Lordship, till date, nothing has been done, and this is the current picture for the demolition as the.
Again, November, whatever the order, Your Lordship passed, Your Lordship, look at that order.
2nd November.
2nd December, possibly, last order.
Yes.
Whereby the application or the contempt application was restored.
Yes.
Then what is the application for the contempt, my lord? You see which order has been, my lord, questioned? The violation of which order? Possibly 24th of May 2024.
24th of
May 2024.
Yes.
That is the parent order.
Yes.
That order, my lord, to look into the issue and pass an appropriate action.
Yes.
Action had been taken. That was reported to your lordship on the last occasion when the restoration application was made. Your lordship simply said that I'm not going into right now because I'm just restoring, and then I'll consider. Therefore, the order had already been passed, and order had been passed. That is recorded by your lordship on the last occasion when I submitted a report to your lordship's court.
That is the
2nd December.
a copy of the order.
Order.
Give it to him.
Well, order 408 normally it is not supplied. It is action under section 408. The demolition order has been passed. I tell you, Lordship, what he wants, my lord, demolition order has been passed. Action had been taken from our end. He wanted that the consideration and disposal of the issue. Issue has been decided. Order has been passed. That is reported to your lordship.
Communicate to them. Otherwise, how do they know that you have complied, Mr.
Well,
Unnecessarily they have come. If you have complied,
it is not. My lord, I'm telling you, lordship. It is his contention that he does not know about that. Now, my lord, when 2nd December I reported to your lordship, and your lordship recorded that the order has been passed under section 408. That is the communication to him. He is not interested about the order for challenging that before other forum, because he is interested to dispose of the entire issue. I recorded 3-4 months.
What order you have passed? What stage?
I'll give, but so far as this application is concerned, my humble submission, it just stands for infractions or other. Well, I'll give it to you. I'm giving it to you.
Give it to. Do you have a copy of that?
No, right now it's not in. Where's the only tip?
We are disposing of by.
I'll give it, my lord.
Kindly keep this matter pending, because till date, Your Lordship, this is the condition. Nothing has been. This is the current picture I'm showing you.
Sir, they have passed an order. Somebody may have challenged that order. What can be done?
And I will request your lordship, my lord, not to.
The party has a right. Only the directions we are concerned whether the directions have been complied with.
The action has been there's a specific direction to action to initiate.
Sir, please kindly come to the order.
Original order.
Yes, original order.
Page number 84.
Page number 84. Please kindly come to that.
The operating portion, Lordship,
Yes,
is
operating
85.
part, please.
85.
Is that 85? Disposed by directing the commissioner to consider the representation, direct one of its officers to conduct a surprise inspection of the building, examine any planning permission was obtained, and if not obtained, appropriate actions be initiated under such and such act. If planning permission had been obtained, the authority should also consider as to whether the building has been put up in accordance with the sanction plan. If not, action should be initiated. So that was the only direction. Mr. Ghosh says action has been taken. They have passed an order. Somebody affected party may challenge. Maybe.
And in fact, well, we had taken certain steps for demolition also.
This has been done.
Can I give a direction to
Ghosh, we are disposing of by recording. That
Yes, but in the next by next week, my lord.
yes.
That has been recorded.
The order dated 2nd of December 2025 once.
My lord. When that is not within, my lord, let me, my lord, no.
We are.
I'm showing.
My lord.
You have a copy.
Yes, Your
Go to second page.
My lord.
Your submission was noted. Mr. Ghosh submits that since some portions of the building are occupied. The demolition work could not be done expeditiously, and the alleged containers have already approached for police assistance in this regard. Prima facie, it appears to this court that the demolition order has not yet been completed for such reason. What is
But
the stage of the
I'm
demolition?
submitting, bro. First of all, that was reported to your lordship.
We have only revived.
No, I am submitting to your lordship not for that, because your lordship revived because the order we could not inform to the court that the action had already.
No.
No, on that, not on that date, on that earlier occasion. Earlier occasion, these days, this has got no related to the parent order. Your lordship, just I reported to your lordship regarding non-completion.
No. Parent order says that you will consider the representation, you will see whether there is any planning permission, whether there is any deviation or not. That was the parent
This
order.
concluding of the proceeding. Conclusion of the proceeding. No further order. My lord.
Yes, what is the stage of demolition, Mr.
Madam, we have been proceeding. There are some difficulties. I reported on the last occasion. The police has been impeded. Some portions are occupied. Therefore,
Taking steps for that.
taking steps. I am taking steps. And my lord, if he is agreed, because on the last occasion, I also submitted, you know, maybe please to pass the direction of the police to get it. Because I cannot. Because in this particular proceeding, when the order has been acted upon, there could be done in a separate proceeding. That police assistance or something like that. We have demolished certain portion of the building also.
According to they are stating that they are demolished.
No, upper floor. I mean not say.
We have to confine ourselves to the scrutiny of whether the directions has been complied with or not. So let us see what was the direction, then
I'm some
Just record my objection, nothing else.
only I'm submitting one thing. Plan or something like that. Whatever Illoshi is adding, of course, Illoshi is not making anything.
Not added. We have only recorded your
The recording, another thing is that it might not come, that the progress is not stalled, not progressing, not done. Again, content petition, because this could be a separate proceeding. That is the reason I'm submitting. Because my lord, no, my lord. Otherwise, my lord, difficulty would be, my lord, because the coordinate bench of a lawsuit say that beyond parent order, no order could be passed in a contempt jurisdiction.
What is contempt? Contempt is a positive
Is a direction.
So here-
I know.
so,
But my lord, even
Mr.
then,
Ghosh-
sometimes, my lord.
Mr. Ghosh, you are sufficiently.
No, I know, my lord, that is true.
So, we have observed.
Yeah, lawsuit has just
we have
recorded.
that paragraph. We have observed, and since Mr. Ghosh, you being an authority, you have to see that your order is to be
No,
implemented.
that is the thing.
So we have only
But
recorded
sometimes, my lord, as I said, our order has to be implemented. That is my also not only my
only
authority,
recorded
the
your
court's
submission.
order to be implemented.
Mr. Ghosh, we have only recorded your submission. We have not passed any positive direction.
My lord.
আচ্ছা,
Yes. Yes. I know. Now, my lord, Lordship has looked into the Government Buildings Act 1899. Now, my lord, kindly takes up the affidavit in opposition on behalf of the respondent number 4, the Public Works Department. Has your lordship found it? But kindly give me my lord's brief, I will find it. Didi, একটু নিন। 4.
Yes.
My lord, upon by Chandan Kumar Sarkel. Kindly turns to the second page, para 4B.
Yes.
It is stated, originally the cause of action arose on the basis of a writ petition filed by Shukdev Bera, which was registered such and such, where the said petitioner had complained that the chairman Haldia municipality unauthorized encroached over just in front of his Rayati plot, such and such, such and such. As I said, my lord. Then, my lord, so far as after B, then, my lord, there are certain C, D, E, my lord, the series of what had happened. Now, kindly comes to paragraph 4K at page 5. Down the line, my lord, it is submitted that as per provisions of the Government Buildings Act 1899, there is an exemption to the government authority for construction of any building as per provisions of section 3 of the said act, and only layout for plan is to be submitted to the concerned municipality or panchayat. Now, where there is no municipality, the act says municipality, but they say also or panchayat. May I just read it once again, my lord? It is submitted as per provisions of the Government Buildings Act 1899. There is an exemption to the government authorities for construction of any building as per provisions of section 3 of the said act, and only layout for plan is to be submitted to the concerned municipality or panchayat. Now, my lord, if I seek to draw, my lord, a certain, my lord, interpretation of this particular paragraph, it comes with an affirmation that in terms of this act, so far this act is concerned, there is an exemption to the government authorities. Now, my lord, being a local body, apart from, my lord, it is a body corporate, comes under Article 12, being a state, I am also a government authority. 243Q says, and it is no more res integra, that municipality is also a government body. That is also, my lord, held and decided by the Honorable Supreme Court. So far, the other party is concerned, my lord, that for construction of any building. Now, my lord, the third part is that in terms of section 3 of the said act, and fourth part is this, that layout for plan is to be submitted to the concerned municipality. Now, my lord, keeping this particular paragraph, my lord, in a true sense and spirit, read in the light of the Government Buildings Act 1899, kindly, my lord, just in order to buttress my first limb of submissions, my lord, kindly have a look to the judgment delivered by the Honorable Division Bench, where, my lord, the author was, my lord, Justice Honorable Senior Bhattacharya, my lord, reported in 2016 volume 1 CHN Calcutta. My lord, kindly record it. It's a SCC online printout, but it's also reported judgment. 2016 volume 1 CHN Calcutta.
2016 1
Cal.
CHN Cal.
329.
Yes. For what proposition you are trying to?
My lord, so far as section 3, Government Buildings Act, my lord, how it is to be dealt with. My lord, kindly comes to, my lord, what are the facts? My lord, kindly see parag 1. May I just place, my lord?
Paragraph
1. Kindly see what are the facts. My lord, every precedent, my lord, as I have learned, my lord, depends on the facts of the case. May I place, my lord?
Yes, yes.
Yes. The High Court Employees Welfare Association demanded for immediate installation of.
Read the facts. You can tell me the facts. What are the facts?
My lord, the facts which are like this, my lord, that there are the demand of my lord, installation of laying of air conditions, my lord, system, and for that purpose, my lord, certain, my lord, infrastructures are required, and for, my lord, making of certain infrastructure, it was, my lord, decided vacant land was, my lord, there inside the High Court presents, my lord, where kindly comes to, my lord, first page, last portion, for implementation of the said project. Lordship has seen, my lord?
Yes, yes.
Some additional construction was necessary for installation of AC plant therein. Accordingly, a vacant place within the High Court compound area was selected for raising such construction for installation of the AC plant and also for relocating office of PWD department in a portion thereof, in as much as relocation of all the offices of the PWD in one place was found to be necessary for effective maintenance of the High Court building. Ultimately, with the permission of the government competent authority of the Forest Utilization Division Bench, certain trees were felled down from the proposed construction site. The building plan was prepared by the PW department, such and such, and after High Court administration, the government estimated the cost. Thereof, the construction was commenced by the PW department, State of West Bengal, and by this time, construction has almost been completed. Now, Miller kindly comes to there was also, my lord, a claim that there's a High Court building, my lord, was considered to be of.
Conclusions of section 3 is paragraph 37.
Yes, I'm coming to that. But
Let us
there are.
come to paragraph 37.
My lord.
First part section quoted, paragraph 39 is the observation of the Honorable Division.
My lord, prior to that, may I just request your lordship? May I kindly request your lordship? Comes to, my lord, paragraph 34. He thus contended that none of the provisions of the Government Buildings Act 1899 has been amended and repealed and or inconsistent with any of the provisions contained in any of the articles under Chapter 9, Capital 9A of the Constitution. The provisions of the Government Buildings Act 1899 cannot held to be inoperative after expiration of 1 year from the commencement. Finding of the court, para 35. We have considered the submission of the council of the parties, and we find much substance of the submission of Mr. Mukherjee, Mr. Kaur, as we find that the Government Building Act 1899 still remains unrepealed, and the subject of legislation relates to subject under 2646(4) of the Constitution of India, and the provisions contained in such legislation is not contrary to Article 13(1) of the Constitution. We further find substance in the submission of such and such that since the provision contained in Government Buildings Act are not inconsistent with any of the provisions contained in Chapter 9, Capital A of the Constitution, the provisions contained in the Government Buildings Act cannot be held to be inoperative after expiration of 1 year from the date of commencement of the Constitutional 74th Amendment. That apart, legislative competence to legislate on state laws is subject to the Central Act. Besides, the exemption which was given to the state government under the Government Buildings Act cannot be held to be inoperative, as despite knowing such exemption given to the state government by the unrepealed Central Act, state government, while legislating on the municipal law, did not make any contrary provision in the municipal law by making the provisions of the Government Act inoperative, as it was done in Andhra Pradesh state legislature, even though through the state legislature was competent to do so under Article 246(3) of the Constitution. Thus, we have no hesitation to hold that the Government Buildings Act is still in operation, and as such, we cannot properly interpret the meaning of the expression person mentioned in various provisions under Chapter Roman capital 12, 22 of the KMC Act by ignoring the provisions contained in the said Act. Now, my lord, para 37, what your lordship, my lord, has considered this effect of section 3. Let us now consider the provision of said act in the present context.
Come straight away to 39, Mr.
My 39.
37
is a
considering 38 is section 3
Mile.
quoted. You have
If the provision
the place
mile.
39.
If the provision contained in section 3 of the Buildings Act is read conjointly with the provision contained in chapter Roman 22 of the KMC Act, then we have no hesitation to hold that by implication, the state government was exempted from complying with the provisions contained in the building rules under such and such act when the state government construct building on its own land or in the land occupied by the state government. Thus, we hold that the expression persons used in sections 392 and 393 of the KMC Act does not include the government when the government constructs on its own land or in the land in occupation of the government. Then discussions on ownership, para 40. Even by holding as such, we cannot conclude as to whether the construction which is raised within the High Court compound is legal or not without resolving the other dispute which was raised by the petitioner relating to ownership of the land on which the High Court building stands. By referring to the rate such and such, Mr. Such and such submit that the Registrar Calcutta High Court was recorded as the owner of the said premises. He thus contended if the Registrar High Court Calcutta is the owner of the premises and the government building tax has no application in the facts of the instant case, as this is not a construction made by the government on its own land or in the land which is in the occupation of the government. Let us now consider this part of submission in the context of pleading of the parties. Though we find no reference was made by the petitioner in the petitions about the ownership of the land on which the impugned.
Mr. Basu, are you on the ownership?
No, I am not on the ownership.
Placing the entire judgment.
Well, kindly comes to.
Please don't place the entire judgment. The point which you are trying to rely upon, you have placed.
Well,
You can proceed to the next judgment or the next point.
Well, it kindly comes to para 55. Has it also found, madam? Discussions on the requirement of service of notice. Even on holding that we cannot conclude the issues without addressing the dispute regarding legality of such construction in the light of provisions contained in Government Building Act. Though Section 3 of the Act gives exemption of a certain building from municipal law to regulate of the building of the municipality, but still we find that the unfettered right of construction without the proper authority was not granted to the government under Section 3. Section 3 of the Act provides that reasonable notice of the proposed Act shall be given
What
to
is
the.
your submission on this? What you are trying to say from this?
So far as my submissions on this, this is since the construction is made by the municipality itself. So far as the proviso clause of section 3 says, the intimation has to be given to the municipality. So here, the municipality itself decided on its own meeting, to make and raise these constructions upon getting permission from the concerned or recorded owner, Public Works Department. So, this compliance has been made by the municipality authority itself. That first they have sought for.
The paragraphs which you are trying to rely upon is may not be relevant in your case.
Very well, very well. Only I try to show. Then, kindly comes to then.
What you are trying to show? The effect of non-service?
No, not effect of non-service.
What point? Please, you can tell me, because I have read some of the portions of the judgment. I can also help you. Because non-service, the conclusion also I can help you with the paragraph.
I was
the observation of the Honorable Division Bench. So you can tell me which point you are trying to search out. I can help you.
Kindly comes to paragraph 58.
You can come straight away to paragraph 61. That's the ultimate conclusion on the effect of non-service.
Very well. We thus hold, but before that,
this is the conclusion. You
yes, conclusion.
61.
61.
That is why I told you, can tell me which you are searching. I can assist you with the paragraph.
We thus hold that service of notice upon the municipal authority before commencement of the act as contemplated under section 3 cannot be held to be a directory. In our view, service of such notice upon the municipality before commencing the work is mandatory in nature, and in case we hold it otherwise, the modalities framed under section 4 of the said act will
So
become
it's mandatory. Service of notice is mandatory.
mandatory.
So it's against you. So
Now,
now your submission is that since you are the municipality, it's not required. So this judgment, this portion may not be relevant for your case.
My lord.
Yes, you can come to the next judgment, Mr. Basu.
Now, my lord, here, my lord, kindly see one paragraph.
Which point? Please tell me the
My lord,
point.
on considering, my lord, section 3, well, possibly I have already placed now.
Mr. Basu, in your case, according to you, you are not required to serve notice under section 3. So why are you going to that issue?
No, my lord, I was just looking into this particular aspect. My lord, this enjoyment of making a constructions or my lord, permissions to move, my lord, make a constructions, my lord, in terms of the Government of Buildings Act.
All right, you can include that in your notes. Please kindly come to the next judgment. Yes.
My lord, the next judgment, my lord, kindly, the next judgment reported in AIR 2019, Calcutta, page 9.
Yes. On what point?
Page 9.
Yes, give me a copy. On what point you are trying to show?
My lord, there was also a construction made by the Defense Authority, my lord, on its own land. And my lord, the Kolkata Municipal Corporation, my lord, raised my lord, objection.
গভর্নমেন্ট বিল্ডিং একটার উপরেই আসবে।
Kindly see, my lord, this is also a Devanshu. My lord, kindly see, my lord, paragraph 9.
Yes.
Now, my lord, see para 11. In view of situations.
Yes, yes. The defense authorities can raise construction on their own land without obtaining permission from the Kolkata Municipal Corporation.
Defense and other, my lord, there are some other authorities there. Now, so far as my submission is there, my lord, that since the here, my lord, the person concerned itself a municipal body.
So
And
you are on a much better footing.
now, my lord,
Defense.
my lord, the one other point, my lord, what I tried to show, my lord, that the operation and the application of this Government Buildings Act 1899 for making any construction, that was also considered. And here, Lordship may kindly look into that act itself, where it is stated for a public service and for a public purpose. Now, by my Lord's order, Lordship has recorded submissions of my some documents. কবে আছে? 3rd February না কবে? অর্ডারটা দিন। Well, kindly see my Lord's order, 3rd February.
Yes.
We have filed certain documents where your Lordship has recorded filing of some documents, and we also supplied to the other side, both to the state and the private respondent. Now, kindly takes up the first document.
You have filed by way of an affidavit, or you have filed a bunch of documents?
Bunch of documents. Lordship has also recorded bunch of documents with a notice to them.
Yes. Yes.
Yes. I have another copy, if Lordship doesn't find it.
একটু করে দিত এই সব অর্ডার শিট গুলো বেরিয়ে গেছে। Copy of those bunch of documents. Yes.
The first one is a handwritten copy where we typed it on the next page. It was a letter issued by Assistant Engineer, Public Works Department, Holdia Subdivision, addressed to the notified area. At that point of time, municipality was a notified area.
Yes, yes.
18/1/1988. There is a memo number. Proposal for transfer such and such, such and such. Now kindly see body. In reference to your above mentioned letter and in consideration of public utility service, kindly underline this, to be rendered by your authority and in anticipation of the Executive Engineer Tomluk Highway Division's approval, you may start the construction work of office complex of your authority of such and such meter land at Dagdamba such and such of Moja Durgachok. Lordship has seen, now see, the bottom portion, copy forwarded to the Executive Magistrate Engineer Tomluk Highway Division for his kind information necessary action. The Holdia Notified Area Authority is pressing hard, very hard, to construct their administrative building on the aforesaid plot for the interest of public service, and accordingly they made several correspondences and pursued verbally. As we do not have any objection, Lordship has seen, do not have any objection to hand over the aforesaid land to the Holdia Notified Area Authority, and as there is no provision for further widening of the road, the Holdia Notified Area Authority can go ahead with the work in anticipation of his kind approval. Under the present circumstances, it is also very difficult to keep the land from the encroachment. To keep the land from encroachment.
Free from encroachment.
Free from encroachment. Sorry, free from encroachment.
That order is that. What is
Exactly. My Lord has seen, Lord.
Yes,
Under the present circumstances, it is also very difficult to keep the land free from encroachment. So, kindly see, may I just refer, my Lord? Kindly see the subject. My Lord, kindly see, আপনি বসুন না। My Lord, kindly see the subject. No, Mr. is a question raised to Mr. Rai.
He is assisting you. Why are you getting
Kindly see Dak number 1452. This is the Dak.
Permission. You construct allowed construction in respect of.
Now, my lord, we have. Now, my lord, kindly see the next page. In response to his letter under reference, this is to inform him that the land in question may be handed over to the Haldia Notable Authority after fulfillment of all formalities for the purpose as proposed, etc., etc. This has reference to the letter of assistant engineer dated 18/1/1980.
Block complex is on which plot?
Isn't that plot?
Which plot? Please identify.
75.
1452.
No, 751 by 1452. My lord, in my affidavit in opposition, I have given the plot number that is 751/1452. And that is not, there is no permission on from any document.
Yes, Mr. Basu, on which plot? You must be knowing on which plot you have constructed.
No.
My lord, so far as দাঁড়ান ললিতদা, আপনি যেটা বলছেন তার তো কোনো ডকুমেন্ট
which plot you have made construction?
My lord, my construction is made on.
Please show me on which plot.
My lord, kindly comes to, this is the part of 1452. This kindly comes to opposition.
1452.
Yes, kindly comes to the opposition of the state again. Lordship has come, my lord.
Opposition of the respondent number 4.
4.
Yes. Yes. Yes.
Kindly comes to para 4I, page 5.
75 by 1 by 1542.
It is their own statement that 751/1452.
Yes.
It's a Batadag of 1452. The originally, my lord, the 1452 was a plot as a whole. Subsequently, it became divided and demarcated under 1452. It is their own statement.
Yes. Yes.
Kindly comes to page number 20.
20 of the
this document, opposition.
Opposition, yes. Yes.
See the schedule according to their document.
Yes. When this construction was made, Mr. Basu?
1988.
Have you stated that in 1988? Where have you stated?
But at that point of time, when the permission was given to raise construction, the construction was made then. Subsequently, only some
statement with regard to that. Have you made any positive statement with regard to that? That when you have made this construction, have you filed any opposition
against, my lord?
Writ petition?
Yes, opposition. Well, opposition filed by them.
Yes. What? No. What is the statement in the writ petition? With when have you made construction?
My lord, may I just check? Milord, if your lordship kindly comes to paragraph 3 of my writ petition.
Yes. Yes.
Three, 4, 5. It was only further a reconstruct and renovate. Now, my lord, kindly see page 7, a portion of para 5. Kindly see, my lord. Haldia municipality from the top. Lordship has seen, my lord. Third line. In discharging, decided to reconstruct the said public latrine and urinal after removing old latrine and urinal on the said land appertaining to such and such. It's there, my lord, since 1988. After the permission being granted in writing that you can raise construction, you can make constructions for the purpose of public utilities and public services. I made a Shulab complex for the persons who come over there for the purpose of a public need. And as I shown to your lordship, this letter itself also discloses that this land is otherwise, my lord, encroached, or the land cannot be kept from encroachment. And it says,
Everybody will encroach, Mr. Basudeb.
my lord,
If the authorities cannot keep a land free from encroachment, so it's a license given to everybody to encroach.
my lord, this is a, my lord, that is, this is,
Has to be.
my lord,
Because if the land cannot be kept free from encroachment, let
my,
all of
my
them
lord, so far as in our daily life, my lord, on many where we find many encroachers from many government land, and particularly in port trust and, my lord, rail lands. Lordship has
that
seen.
is to be. Everyone has a premium to encroach because the authorities cannot keep it free from encroachment.
Now, my lord, here, my lord, the twisting fact and, my lord, the riders which are there, that on the basis of my letter, my memo number was also there, dated 16/11/1988, in response of which
You are
they
permitted to go on with the construction work in
respect of
anticipation of
certain
the.
plots, in respect of, I'm not mentioning that.
Let him complete. In anticipation of because proceeding is going on for processing your application for permission.
no processing for application, even for transfer of land.
Yes, transfer.
Transfer. So if we say in a two different parts, one is transfer, one is construction. Now the construction has already been permitted. I raised the construction.
Promissory estoppel.
Now, my lord, promissory estoppel.
How many decisions on promissory estoppel, Mr. Basu?
My lord, according to to my understanding, so far as I could find the best judgment on promissory estoppel, I have bought that.
So you place only the best judgment.
Yes.
নামটা দিয়ে দিন।
Because after you rely the best judgment, there is may not be any necessity to rely on other judgments. Just give your best judgment. on promissory estoppel.
I have only one copy.
Yes, you can place that. Yeah, give it to
প্রেস করে দাও, প্যারাগ্রাফটা প্রেস করে দাও।
Yes. Mr. Basu, no difficulty. You can place from that, then give it to me.
Well, the citation is 2016, volume 6. Supreme Court cases. It jot kore dekh na bare pass kine 2066.
Mr. Rai, you are not carrying those gadgets.
Quite comfortable with these papers.
Yes.
Well, at para 12, 13, 19, 20, 23, and 36.
Please mention that paragraph numbers in that.
Fine.
Please indicate that. So Basu, please indicate that in the decision.
Para 12, 13, 19, 20. But this 4 paragraphs on the independent cause of action. Para 22 and 36, use of discretionary power.
Yes.
Now, may I just read para 12? Some mistake, but the judgment is correct. Next judgment is, my lord, 2015, volume 5.
On what point?
State is a welfare state. 2015, volume 5, SCC.
Mr. Basu, you have to cite decisions before a high court.
No, not. But here, my lord, I'd like to show. Just may I just read one paragraph from that? A welfare state denotes a concept of government in which state plays a key role in the protection and promotion of the economic and social well-being of all of its citizens, which may include equitable distribution of wealth and equal opportunities and public responsibilities for all those which are unable to avail for themselves minimal provisions for a decent life. It refers to greatest good of greatest number and the benefit of all and the happiness of all. It is important that the public wealth to be the commitment of the state, where the state is a welfare state. A welfare state is under an obligation to prepare plans and devise beneficial schemes for the goods of the common people. Thus, the fundamental feature of a welfare state is of social insurance. Anti-poverty programs and a system of personal taxations are examples
On that. You are only on those
on this
developments.
point.
Give me.
A welfare state is one who seeks to ensure maximum happiness of maximum number of people living within the territory. A welfare state must attempt to provide all facilities for decent living, particularly to the poor, the weak, the old, and the disabled, and to all those who admittedly belong to the weaker section. Article 38, 39 Constitution provides such and such. These rights may cover means of livelihood, health, and the general well-being of all sections of people in society, especially for the young, old, and such and such. The groups require such and such, and the welfare
But
state.
remember this, Mr. Basu, when you come, your municipality comes as a respondent. I will have to apply that because this is what you are following.
My lordship
should be
Lordship, my lordship, while at that point of time I was assisting at the bar, your lordship, and sometimes also against it happens.
Yes, paragraph welfare state paragraph 9. So I know that you are following these principles. That is why.
Kindly forget that part.
You are not following.
No. For this matter, lordship is always deciding a matter in hand.
It's very good that you are looking up on the well-being of the citizens, maximum happiness for the maximum number of people. That can be tested in an appropriate case also.
course, my lord, but on a different facts, not on them, but in these facts, my lord.
On that fact, this principle has to be applied.
Of
Mr.
course,
Basu.
of course.
বললেন না 2015
SCC is 813.
813
Now, my lord, I've got this judgment, para 12, 13, 19. My lord, that's promissory estoppel.
Yes, give me.
My lord, paragraph 12.
You have got the judgment?
Yes.
Give me the judgment.
But SCC copy. But kindly have a look from, I mean, I'll just find it from my para 12, 13, 19, 20.
Please give me a photocopy of this.
Yes, I will do. I'll do.
Yes.
সেটা খুলছে না। আমাকে একটু দেখতে দাও কি পড়ছো।
Yes. Yes, Mr. Vasu.
My lord, paragraph. My just phone is opening the SCC. 12, 13, 19, 20, 23, and 36. Kindly give me a moment.
12, 13.
My lord, may I just repeat once again? 12, 13, 19, 20, 23, 36. Oh. ভুল নোট করে দিয়েছিল। হ্যাঁ দেয়নি দেয়নি ঠিক দেয়নি। যাহা বলিব সত্য বলিব, সত্য বিনা মিথ্যা বলিব।
Yes.
Well, may I read para 20? Lordship has seen already. The above statement made on various earlier English authority correctly.
The basic principle was laid down in Motilal Padam.
Mile.
That's the parent decision on promissory estoppel.
Motilal.
So subsequent decisions have been
But here, my lord,
followed, and exceptions also have been carved out in one of the decisions.
and my lord, here, what I would like to qualify this by saying this also applies to the government. With this judgment.
Yes, yes.
So government
There is
cannot
no
say.
dispute with regard to that.
Yes. The government cannot say. আমার এখানে কাগজটা কোথায় থাকে? থাক ওকে থাক। ওকে দিয়ে দিন। So government cannot say that it doesn't apply to me or doesn't bind me.
It's against government, Mr. Promises. These decisions are on that. Nobody can say that it does not bind the government. Most of the decisions on promissory estoppel is
On the state.
And basic principle is acting on the representation. You have altered your position to your detriment.
Yes. To your detriment.
To your detriment.
To my detriment. So here, my lord,
that's the basic thing.
And here there's onus on them.
Detriment is to yours.
To you. And the state has to show.
No. Why state has to show?
No, sorry. I have to show it's my detriment. I'm just.
You have altered your position.
I have altered.
What was the representation? you have altered your position to your detriment.
To my,
That's what's.
this is the exactly, my lord, the
Yes,
catch
please.
principle.
Yes. Please give me a photocopy of
Fine.
that. Yes. Next.
Your lordship, continue now.
Please continue. Yes. You have completed 3 points. You have completed only 1 point left. Commissary estoppel also completed. Yes.
No, but I have to now show some
You are a
pleadings.
busy counsel, Mr.
No,
Boss.
I
It's
am
very
not busy.
difficult
Man.
to get
I am
you.
not busy. Man. But I have
I
to
think
show.
at this time,
I,
you are free. You are not engaged
No,
in some other court.
no,
Please.
lordship is kindly embarrassing. Man, do not embarrass me. Man.
No.
But again,
Brother,
my lord, they will
it was
reply.
a lighter note. How much time? You have said 1 hour. 1 hour is.
No, I have to now show some pleading part also, my lord, from the pleadings of the parties. But also my statements, my
Any
lord.
decision you want to rely upon?
My lord,
Any point of law you want to argue upon? Pleadings with regard to what you want to show, please specify that. Indicate that.
my lord, pleadings with regard to that my this constructions being made not for any individual purpose, not for any personal gain or benefit. It is, my lord, on different propositions. One, the Government Buildings Act 1899 provides construction of such a building on a land. My lord, if I go for a construction part only, then construction is permissible. Secondly, the permission whichever, my lord, requires, that is also being given. Thirdly, my lord, I raise the constructions. There are two parts under the municipal law. This part, my lord, fallen as an obligatory parts. So I complied my statutory duties, as well as I provided which are the parameters. It has to be for a public service and a public purpose. There is no denial. Now, my lord, the facts which may be in a dispute or maybe, my lord, purporting to be in a dispute, which is not dispute at all. Because what I understood, my lord, that there may be an objection that this is not that dag number. That dag is also a same dag. This is on a same plot. My construction was there for more than 40-45 years, after 4 decades. And I am also told, my lord, one very interesting point, which is though on a very fact, that the PWD office which they maintain, it is, my lord, within 100 feet. Not for now, from then also. From 100 feet just opposite, they are seeing these constructions has been made from 1888. Well, they did nothing. It is by them, my lord, according to their own accord, I raised these constructions.
They have admitted in their letter that this property cannot be kept free from any encroachment. That is their letter.
Well, so
no, because they are saying they cannot do anything.
Well, now she is free from encroachment from whom? From
everybody.
From everybody. Now, the particular purpose, there are other 2-3 documents, my lord, in order to see, my lord, some outsiders, some, my lord, some intruders, who, my lord, come and occupy and make their own place of inhabitant, which may not be permissible, what we often see, my lord, in many places. Admittedly, my lord, we find those places, my lord. Here, there would be a public cause, there would be a public purpose, and municipality and the notified area at that point of time was harping on that issues. And it was also, my lord, unequivocally agreed that yes, these portions are needed, and they also say that these lands are not required. By us, it is not required. So it is left. Now, it's a left out land. If something can be utilized for a benevolent purpose, for a beneficial purpose, so why not there would be a construction by the municipality for the persons who attend and visit the bazaar. So this part, my lord, I have to place. And the second
That you have placed. What more? I accept that.
no, my lord, so far the second part is that then, my lord, this West Bengal Highways Act, in my understanding, my lord,
This
does
West Bengal Highways Act.
my lord, kindly take it up on the next day, my lord.
Sir, please complete it. Yes. Yes, West Bengal Highways Act.
But then again, they will make their objections, my lord.
No, kiser objection.
And my lord, this I also take this point. May I just
Yes. Section 3, no declaration has been made.
My lord.
Section 26.
Yes, no.
Saving clause.
Prior to that, please come, my lord.
Yes.
The right of the
My lord, so far as according to this section 2B, the encroachment. What is encroachment in terms of section 2B? That means any occupation or use of any highway or part thereof by any unauthorized person. Now see, my lord, unauthorized. I was being authorized. So if I was being authorized, so prima facie, my lord, this act doesn't, my lord, apply to me, my case. And my lord, with the deepest of respect, my lord, lordship may decide the case either on the favor. We are here, my lord, we are the learners. But every day we are
I'm
learning.
also learning, Mr.
My lord, your lordship's acumen and wisdom is far, far better than at least me. Mr. Rai, my lord, is ahead of me, much ahead. Now, my lord, now here, my lord, 2B, my lord, everything would boil down from the very beginning.
You are authorized occupant, you do not fall within this.
Because 2B is the first parameter. So they have encroachment. Encroachment means, well, it has some riders, any occupation such and such by any unauthorized person. So my occupation, they have is authorized. Now, kindly see the next part. On the other day, your lordship was, yesterday, my lord, I was online. I was considering from their submissions, my lord, that according to this, the structures would be for a temporary purpose. Section 8. Lordship also was, because my duty is to also say, my lord, this permission to make encroachment, no person, but if your lordship kindly see the subpara 2. Highway authority or such officer having due regard to the convenience of such and such as may be, now I'm going to kindly see the first one. The permission to make encroachment, no person shall make encroachment without obtaining previous permission in writing of the authority or any officer not below the rank of an assistant engineer. So not below the rank of an. Now second, the highway authority officer may having regard to the safety and convenience of traffic. Safety and convenience of traffic. It was also an issue because I wrote that there was a huge congestion. There was a regular report of an incident of an accident. So that has to be taken control of, because otherwise intruders, the ingress and egress of the general public are being seriously affected and there the roads are being blocked. Now here, grant a permit to any person to use or occupy temporarily any land appertaining to or adjoining for such period as may be specified therein. Now here I was permitted to raise constructions. I was given a possessory right. My right to raise, not only to occupy, but to raise constructions. Kindly view on this angle also. It is not something is
permitted under section 8.
No, if it is an alternative submission, my lord, because my submission is, if so far as my first, second, and third point, this
alternative submission that you have been granted permission under section 8.
I say, I do not say, man. I say, man, so far as according to them, that the permission, what is required in terms of section 8. Now,
that was not their submission.
Then, my lord, I understood wrongly. I understood wrongly. Then, according to them, possibly, or if your lordship may kindly, my lord.
Section 8 permission is for temporary purpose, not permanent purpose.
Not permanent purpose.
That was their submission.
Now, here, the permission, what was granted, or according to them, it's only for a temporary purpose, not for a permanent purpose. Now, here, this section 8 would only apply if this act applies. If this act doesn't apply, the section 8 doesn't apply.
No provisions will apply.
No provisions will apply. Now, so far as this section 10 is concerned,
will also not apply.
Will also know. There, but just may I just for my lord assistance, if any person 10(1)(a) is found to have made an encroachment, so this finding has to be also there. Now, this finding has to be made in consonance with section 2B.
Yes, no difficulty on that.
Now, kindly comes to my lord section 26.
Yes.
Nothing in this act shall affect the right of any local authority to make any excavation for the purpose of laying, making, altering, repairing, or renewing any sewer, drain, water course or other work.
According to you, that government building act overrides this. So this also will not apply.
Will not apply in that case. But if otherwise, if your lordship's my lord's pleasure and wisdom say no, then my lord, this part of submissions, my lord, here also, my lord, what would be the definition of work? If may I just take a reference that this work, my lord,
To you, 26A allows the local authorities to construct anything. on
construct
highways.
anything. Now, my lord, I do not know whether the constructions could be made below the earth or above the earth. If the submissions, my lord, come from is under the ground, I do not know. But the construction has to be made above the earth, and the construction cannot be made on here. So it has to be seen. Now, so far this work is concerned. My lord,
Other work is everything.
everything. Now, my lord, may I just indicate? Kindly correct me, my lord. But then, so far as this part would fall under entry 35 of list 2 of 7th schedule of the Constitution, where this work, what is the definition of work? If your lordship may kindly also look into that part also. This is a civil constructional part. This, the definition of work.
So you are trying to expand the scope of the writ petition, your argument, it's very difficult. Because the basic principle of ejus dem generis,
My lord.
that you are leaving apart. You are going to article such and such schedule. This can be interpreted with by taking the help of the expression ejus dem generis.
My lord, for that part, my lord, I just, but for that part,
trying to elaborate.
no, I'm just,
expand the
no,
scope
I'm
of
not.
Other work includes everything.
No, my lord, I'm not expanding. I'm just, my lord, for a my lord, academic purpose.
You are trying to refer.
No, I'm not referring. My lord, what I say, my lord, what for just only for academic purpose. I
Other
only
work
refer.
includes any permanent construction for any purpose.
No, I do not say that. I say that definition of work means, my lord, any civil constructional work for any
Anything
purpose.
for any purpose. It may be a 3-storied building.
No.
It may be a 4-storied.
Here, my lord, no. Here I say it's a public purpose and public service.
Anything you can for a public purpose, for those who comes to the bazaar, they make stay for the period. 4-story construction also can come within this.
No, my lord, what
Local authority can
no, my lord, what I say with the deepest of respect, my lord, my submission is only with regard to the public service and public purpose.
Public
Nothing.
purpose. I am on
Nothing.
the public purpose.
And
so any type of work for public purpose can be done.
now here, my lord, this
And work is according to you a civil construction work.
and it was a public urinal. It is a public urinal, and this section 26, it also starts with a non-obstante clause that nothing in this act shall affect the right of any local authority to make any excavation for the purpose such and such, laying such and such, or repairing or renewing swear such and such. Now, if your lordship kindly looks into the order impugned,
Yes. Yes.
my lord, the kindly takes up the opposition of respondent number 4.
What for? What you are trying to show?
I have read the order, both the order.
No, from the impugned order.
Impugned order.
Impugned order is not in the writ petition.
There, but it is much more fair and but the
is not
legible. No, it's not that much this legible, but I find these are much more legible.
Page
24.
Well, it kindly comes to
yes.
So, third paragraph.
Yes.
Peruse all the document, including the report of BLRO such and such, considering all the factors from the hearing, it appears to the understand that there is unauthorized encroachment on plot number such and such 751 of 1452
Plot number.
Moja and classified as non-injury such and such PWD in front of Riot plot of 751 and 752. Hence, in terms of such and such, my lord, I direct for taking possession. And my lord, now kindly comes to page 27. this DM's order,
Yes.
fourth line, it says this building according to this classification or record of rights, it belongs to development department. There is Shulof toilet and drain over plot number 7514 as per the report and hand sketch map. It is seen that there are encroachments over government plot number such and such. And the estate engineer stated that the Shulof toilet is constructed on plot number without NOC or PWD. Where the records say that there are permission given on the basis of which I raise construction. And the authority in a very terse manner by both the authority, the first authority as well as appeal authority, are in a very terse manner only recorded that I consider all the documents and I am told or I find
According
that
to you, an unreasoned order, non-speaking order.
there are nothing has been seen other than this.
Non-speaking order.
Is a non-speaking order. The estate engineer sir is without after hearing all the parties and careful perusal of the record, the order dated such and such is upheld and the such and such authority is directed to recover possession and remove encroachment. So here, my lord, the constructions which being made on a permission, which was there for last 40-45 years,
Cannot be directed to be removed in this fashion.
and so far as my constructions over there, it is already made and constructed in view of an exemption, and there are
That you have already submitted.
So,
may not repeat that. Anything more?
These are all my submissions,
So you can file
If-
your written notes. When
Malad-
you can file your
Malad,
written
if I find something more, I may need 2-3 minutes just to filing at the time of written submission. I may point
notes.
out.
No further argument. You can record include.
No,
that
I
in
do
the-
not know what they would submit in response. If they submit in response,
Yes,
then
Mr. Rai. Anything? you-
First of all, the bunch of document.
Yes.
Here, the proposal was also for plot number 1452, but that was denied.
Yes.
And plot number in question is 751 by 1452.
Yes.
And my lord, kindly see my lord page 14 of my affidavit in opposition.
Yes.
It is Noyanjuli. And any construction over Noyanjuli is, my lord,
Yes.
is detrimental.
Yes.
And the order my landed friend has already passed, I need not to place it. I need not to place. And this, my submission is that, my lord, till date, the plot has not been transferred to the municipality. And municipality is not owner of the land. PWD is the owner of the land. And if any construction, even considering section 3 of the Government Building Act, permission ought to have been taken from that, and layout means I am saying that any hospital, when an hospital is doing that,
So they are saying, Mr. Mahato,
layout is,
I will have to approve the plan. I am the authority. I am constructing.
then that plan has to be placed before the meeting, that this is my plan, I am constructing 1-storied building, 2-storied building, 10-storied building. A layout is, my lord, in my affidavit I have stated that exemption is there, I am not denying that. But layout is necessary. Unless there is a layout, there is a scheme, there is a plan by engineer, this will be constructed. It cannot be. Well, this is my.
Sir, anything on, yes,
Section 3, my lord, this is related to the main thing is section 3.
of the government building?
It is only for the purpose of construction.
Construction.
It is object of the act is not to allow permission granted for the purpose of utilization of a land. There is a construction of a building. That's exemption granted to the government or the government authority regarding there is the building plans of either the panchayat, municipality, corporation for exempting from under that purpose. It does not authorize that you have authorized to execute the work or make construction somebody else plot. The basic difference is that it is not exempted from the same. Permission is necessary, but so for the mode of construction, whether the building regulation 3 feet wide, 4 feet wide, or I need a dry land in respect of every floor or not, that is exempted. For that purpose, this is the type of construction I want to make. I need a vetting. It does not authorize the municipality or any other to make construction to somebody else. And so far the illegal construction, probably by landed trade, that in answer to that matter, I am relying upon the old judge head from this court to the Honorable Abhyasta Deepak Mukherjee.
Supreme Court.
Mukherjee is
That is one thing.
Municipal
To
will.
what extent I can lodge a complaint being an adjacent
locus standi.
Locus standi of a third party.
Third party. Apart from that, illegal authorities consider paragraph 8. I am handing over to
এটা দরকার নেই।
No, it affects the fundamental rights failure of the state to take prompt action against the illegal construction made for economical
এখানে কোনটা দেখাচ্ছ?
Deepak Mukherjee.
That is basically on locus standi.
Locus standi. Basically locus standi.
Welfare state. The welfare state has been argued by how the welfare state has been dealt with. That your lordship will find paragraph 8. It was held. The reports of demolition of hutments and jungle jhopris belonging to poor and disadvantaged section of the society frequently appear in the print media, but the seldom gets to read about the demolition of illegally unauthorized constructed multi-story structures by the economically affluent person. The failure of the state apparatus to take prompt action to demolish such illegal construction have convinced the citizen that planning laws are enforced only against the poor and all compromises are made by the state machinery when it requires to deal those who have money, power, and are in excess of the power. But apropos to this, why not kindly consider the construction which are made, though it is not necessary. Can you turn to page 59
of the
writ application? I don't know whether the entire municipality is using this Sulabh complex for the purpose of, because this is a commercial complex. It was held.
My lord, may I just indicate he is trying to, my lord, make out again a case of ingress egress, which by his own action he came
Mr.
to.
Basu, you
Very
have made
well.
your submission.
Very well.
I does not disturb you.
Very well, man. I'll show it in my.
Yes.
So this is the construction of Sulabh complex. Bottom. Look. I don't know whether the inter-municipal inhabitants of the upper portion is only
for resting purpose and other things.
Just commercial utilized.
That's why I told Mr. Basu. We could have made a 3-story, 4-story because the persons who are coming, they may take a rest for some.
The first floor is for the resting purpose, and ground floor is for, my lord, for urinals and
Now,
sanitation.
looking at the photograph, it was in my mind that you will not construct only a Sulabh complex because you consider the welfare of the persons who come to the.
My lord, as a
That is why I knew it was in my mind that being a welfare state, we will do not one Sulabh complex of one. It will be a more than one story. It's happens it's a two.
And the order of
And Mr. Rai, what is your submission with regard to 26A of the National Highways Act?
This explanation regarding the maintenance of proper storage, my lord.
Yes. Yep.
And this is the what my lord submits from. This is the division bench judgment. The Hooghly, my lord knows the interchange of the Hooghly for the that. Dankuli was directed by this honorable division single bench to demolish the entire stretch of land, whatever the illegal construction. Construction was made by the government itself. This is MAT number 302 of 2019. It is a government land, government constructed, then said, but the proposition is that
reference টা বলো
MAT number 302 of 2019 unreported. আমি দিয়ে চেক করি।
এটা কপি দাও।
আমি দিয়ে চেক করি। Case 3, we have heard.
So state government was putting up a construction of the PWD.
Yes. Then also, can you turn to page 3, internal. We have heard the land council. In principle, we agree with the land signatures that nobody is above law. Even the state government has to act in accordance with the law in compliance with the mandatory statutory requirements. The Department of Punjab Rural Development Government of West Bengal, which is responsible for the impute construction, could not have put the construction without the prior permission of the highest authority. They have said that we are already in process of permission. The court says if that be done the post facto. It is not the case over here.
দেবে judgment.
There is total denial on the part of the government that they never transferred. Therefore, the appeal was made, that is pending for consideration. That I say premium was given to the government because it is a government and government authority. It is not a statutory body. It is categorically held, no construction can be made. Post facto approval and other things, if there is at all any.
I've seen this. Yes. All right. Yes, when can you file your notes?
Well, may I just
Answer this, yes.
well, may I just start from this judgment? Here, the factual basic difference is
Judgment.
the last judgment
Yes,
that they have shown.
yes.
The basic difference, kindly see the last but third paragraph.
Yes. Yes.
No, sorry, minute. No, third page, last paragraph,
Yes.
Yes, the
last portion.
judgment.
However, we have told that the concerned department of the state has applied to the authority for permission to make construction. So there is an entire factual difference. It doesn't apply even. Here, my lord, I have applied for and I was given permission.
Granted.
So, my lord, a factual difference, my lord, makes the entire judgment, my lord,
For
inapplicable.
that, you don't need to cite a decision.
No.
Yes. Any other?
So, my lord, this judgment doesn't help to them. So far as Deepak Mukherjee is concerned, it only says about my lord, illegal constructions and a person's right to make a complaint. Now, my lord, the two tests. A person's right to make a complaint, it is no more res itigra. Deepak Mukherjee has settled that. Only the accident. So far as illegal constructions are that, my lord, it is not the case or something as make out of a blue that the constructions are unauthorized or illegal. It is for the first time. Now, here the construction is stated to be made on a PWD land without permission. If the permission is being given or the consent is being given, then it cannot be said to be illegal. The right of a person to apply or to make a complaint to the court that there is an illegal construction, please see and ensure that the rule of law shall prevail, doesn't mean that every construction has to be seen in the light of that. There has to be a construction without permission. The permission was given. Now, Section 3, the Government Buildings Act, which lays down that the government can make a construction for public utility and for public service and purposes. There is no answer that the construction is, even the PWD doesn't say it is not for public utility, for public service, for public purpose.
That you have made.
Now, so far as Deepak Mukherjee judgment also doesn't apply. Now, there, so far as my first, second, and third point, first point is that Government Buildings Act 1899 applies to my case. I do not find any answer from either of the respondent. Now, if that applies, then my construction is said to be legal. My second point, is the case of a promissory estoppel.
Not real.
Now,
Yes,
the last point is this, that so far as Section 26 application, whether they are mere for maintenance purpose and nothing else, this part or consideration would only apply or would only come into for my lord's kind judicial consideration.
This act applies.
Apply 1, 2, 3 point comes in.
If this act applies, all provisions will apply. Otherwise, none of the provisions will apply.
That notes of argument and this judgment's copy, or your lordship may give back to this judgment what I handed over. My advocate on record will compile all these judgment along with my notes of argument, or your lordship may keep it. We shall give another copy.
Another copy দিবি
হ্যাঁ, তুমি এদিকেও বলবে ওদিকেও বলবে।
You have given me how many decisions? The decisions which you have given me, you need not incorporate. The decisions which you have not handed up, please keep copies of them.
I have given you the decision of Justice Jyotirmoy Bhattacharya,
Yes.
Justice Boshak, and possibly this welfare state judgment.
না না এটা দিয়েছি
State from the
2016 টা দিয়েছি
ওটা দিয়েছি
না না
2018 judgment you have given, 2015 judgment of the Calcutta High Court you have given.
These are of Justice Honorable Jyotirmoy Bhattacharya and Justice Boshak. And the
Yes, 2015 5. This
15,
three you have given.
this welfare state paragraph 9.
Give the other judgments.
Well,
When?
Whenever your lordship comments,
No. How much time we will take to prepare the?
this has to be done by me only, my lord. I will do it.
How much time I'm asking you?
Some time, my lord.
What is the expression of some? Please tell me how much time you want.
I leave it to your lordship. I
Please
leave.
tell me.
7 days.
7 days. Next Friday. Next Friday or next Monday week?
Monday week.
Monday week. File your written notes. Thank you, Mr.
Well, would it come under that in to be mentioned or for orders?
To be mentioned.
To be-
To be mentioned.
But if
Forward.
extended
One and a
date.
half minute.